Okay, is it visible?
Yes, it
Yes,
is.
perfect.
Okay, fine.
Acha, not this one. We were talking about the workshop, but ठीक है, this is also fine.
This is fine.
हाँ, चलेगा.
Otherwise, I'll download the other
नहीं,
one.
नहीं, नहीं, this is also fine. Let it be now.
Okay, okay, fine.
अच्छा, during the presentation, Harshita, Ekagrata, you ensure that admit हो रहे हैं लोग, because otherwise we'll be distracted अगर वो भी admit करने लगे बीच में हम तो.
And you have to
Admin we
deny
will take
people
care of.
as well.
Okay,
Because
Harshita, you do it when I'm sharing the screen because
Yes, yes,
अगर
sure.
मैं जाऊंगी तो दिक्कत होगी.
हाँ, so you if you are sharing the screen, the other one can admit.
Yeah, yeah, yeah. Okay.
after 100, you'll not be able to admit, so keep on denying. Because if you admit someone, the other one gets removed. So once the number reaches 99 or something, I think after 99, you'll not be able to
After
admit
100,
anyone.
you will not be able to admit, so keep. अच्छा, guys, we are live now. So
Participants, if you have any queries, you can type in the chat box.
guys, shall we start now?
Can we request everyone to please switch
No,
off?
we should not start right now. Let's wait for others and let this group be full to 100 capacity of the students,
Full.
and then people will
It's
start
already
joining
full.
on YouTube.
It's full, like हो गए 100. We have crossed 100.
अभी और लोग आ रहे हैं यहाँ पे नहीं तो YouTube पे आएंगे तो let them join till 10:05.
ठीक है.
keep a watch on YouTube, Ekagrita, and let us know how many are there watching the video uh, on the MCS core community group.
Alicia, if your query is cleared, you may lower your hand.
Amisha, please share the YouTube link on the third group as well.
Okay.
Good morning, everyone. I welcome you all on behalf of Mudko Society of Law Center 2, the University of Delhi. We are really overwhelmed with the huge response for the CIM registration. I am Deepti Kant, convener of Mudko Society of Law Center 2. Today's workshop will be very beneficial for all those who have registered for common induction mode because today's workshop will cover all the three aspects that is required in mood, and that's why the heading the of today's workshop is Art of Advocacy. The workshop will be divided in three parts. In the very first part, you will be briefed about the last workshop, which was on research aspects of mood code. And the second part will deal with the drafting skills and how to draft a memorial. The last part of the workshop will deal with the oral arguments. So, all those who have joined this today's workshop will be benefited in all aspects of a mood code. And also, regarding queries and everything, I would like to clarify that you can ask your queries on YouTube as well and on Google Meet as well. You should use the chat box and you can send your queries in the chat box. Accordingly, we will see your question and whoever needs to answer, like Harshita or Ekagrata, if these are general queries, then Harshita and Ekagrata will answer. And if the queries are related to specific speaker, then the speaker will answer your queries. Make sure that you don't leave the workshop in between because you have lots of many things to know. Also, we will clarify the rules of CIM today, and many other things needs to be dealt with. So make sure you attend the entire workshop. And most important thing, we won't be entertaining the queries related to what is being already covered in today's workshop, because we have seen many people texting us on WhatsApp and mailing us regarding how to do research, what to do in a research, and what is how to like prepare for CM and all those. Listen, these are very generic queries, and this cannot be answered by anyone in a minute or two. So you need to attend this workshop for this same, because we won't be answering all such questions. And again, about your CIM registrations, I hope you all have been allotted sites. If not, then you will be allotted by today. And you need to prepare memorial only from one side, whatever side is being allotted to you, either the petitioner side or the respondent side. And one most important thing is the deadline is the deadline. No extension will be granted for submission of memorial or anything. Many people were texting us to extend the date for dates of registration and everything. No, this is not possible. The deadline is deadline. We already have more than 750 registrations. So we won't extend any deadlines as of now. Make sure you submit your memorial on time, you register on time, and you do everything on time. And yes, with this, I would like to ask Harshita to take this forward, and we can continue with today's workshop. Thank you everyone for joining.
Thank you, Deepti. Now, I would like to invite Amisha Agarwal for summarizing the workshop which she did last week. Amisha is an executive member of Mood Court Society. She achieved a prize of Best Memorial with her teammates in a national virtual criminal mood court competition in 2022. Over to you, Amisha.
Thank you so much, Harshita. Good morning, everyone, and I'll not take too much of time. I've already taken like a lot of time in the past workshop. So before I summarize the research workshop that I did like in the last week, before that I want to like clear certain queries that I have been receiving regarding CIM. So one of the most important thing is that people are saying that we do not have mails. Please don't worry about the thing that we have received your mails, and we haven't shared any information on the mail yet. We will be sending you the team codes on the mail after this workshop. And if anyone has a query, what exactly is a team code? Like the drafting team will today explain you how to use a team code as well. But just for a clarification, team code is the identification that will be used throughout the CIM for you. So a particular person receives a particular code, that your name will not be used anywhere. Even when you are presenting your oral arguments or you submitting your written submissions, you only have to use that code. And you cannot use your name because of the anonymity that we have to maintain. So for that, we'll be using your mails and we'll be sending you the codes. Apart from that, nothing has been communicated on the mail. We have added you on the WhatsApp group, and if there's anyone who has registered and has not been added into any of the WhatsApp group, you can text us and we'll add you. We'll look into the registration form and add you. If you have not registered, we're sorry, we cannot add you now because registration was a mandate for this. But by chance, if we have missed you to add in the WhatsApp group, or you might have not received the link, we'll add you in the WhatsApp group. And secondly, I receive queries, what are sites? So first of all, I have this request from every student, every participant, that please read the rule book. If you will not read the rule book, you will not understand what exactly is and how exactly it will going to happen. So you have to read the rule book. Every deadline, every submission is written in the rule book, whether it's related to clarifications or memorial submission. The team will, of course, in the end, will let you go through the rule book as well. They'll step by step tell you what exactly and how exactly you have to read the rule book. Though we have covered this in the past workshop as well. And sides, it's very simple that, of course, a moot, when you're going for a case, so every case has two sides. One, the one who has filed the application, the petitioner or the applicant, and the other one who responds to it. So that is what we mean by sides. And one clarity, you only have to prepare one side that has been allotted to you in the sheets. There's your name, your email. Email has been added just because some people have the similar name and there are no surnames. So for that, we have to add the email. So you can check your email, your name, and a site has been allotted to you. Prepare the memorial only from that site. And the last date, as it was earlier told by Deepthi as well, that it is 21st and 21st of March, and we'll not accept any memorial beyond that. Apart from that, I think all your queries will be answered simultaneously in this workshop today. I'll just quickly brief what we did in the last workshop. So after the workshop, I received queries regarding that we are still not clear about how you go about a moot. So for that, I'll just share my screen. Okay, so first of all, what are the stages of a moot court competition? The first thing that happens in a moot court is the assignment of a moot problem. Just for example, I'll keep on making a parallelism with the CIM. So now you have received a moot proposition in the CIM. The proposition, please read the notices, the messages, and book that we provide you carefully, because everything is written in those messages. If you just do not read the messages and directly reach out to us for queries, even we won't be able to help you. I've received a lot of queries regarding the topics, like what topic we have to prepare on. And then the first notice itself, we have given you a drive link. The drive link has everything: your moot proposition, your rule book, your timeline of the moot proposition, your citation style, everything is there in the rule book. So the first step is the assignment of a moot problem in a moot court competition, that this is the case that you will be presenting your written submissions and you will be doing your oral pleadings on it. And then the next step, of course, once you receive the moot problem, you go for research, which I'll just briefly summarize after I'm done with this. Then after research, your next step is you draft your memorial, you do your submissions. Well, Karan and Astha will take care of it today, that they'll tell you how to draft a memorial. And then we go for the oral rounds. We plead before the court our case, whatever we have submitted, like the written submissions we have submitted. On the basis of that, we do the oral pleadings. And this is the most important step in a moot court competition, because, of course, before the oral submissions, you go for a practice round and with your friends, with your teammates, you have a discussion. And in front of your faculties and teachers as well, you can go for the oral practice. This is very important because it'll just help you to basically have a dry run before you actually go and plead before the moot trial court. So in the oral submissions, that is the main game changer. And this is what exactly a stages of a moot court competition looks like. I just hope if there's any query, please ask right now, because earlier also I have received that we do not know what happens in a moot court and how to go about it. So this happens in a moot court. It's just a trial thing, that it's a dry run, that before you actually go to a court and plead your cases. So this is, we're just preparing ourselves to basically for the same.
Also, we will add the drive link to the WhatsApp group. So make sure you keep yourself updated with the WhatsApp group. All the drive links, whatever is relevant, will be added to the description of the WhatsApp group. And the other most important thing is you need to present your case individually. No teams are there. You have your own side. You need to prepare one memorial from the side you are allotted to, and you need to submit that memorial on time, and you need to prepare your oral argument based on that memorial only. Few things are there that will be clarified in today's workshop. You will be asked questions as well from the judges, so be prepared with that. Whatever you have written in your memorial, you may be asked questions in the oral rounds. And also be thorough with the proposition. And the rules of CIM is really very important. If you could not understand any of the point, just reach out to us, or else everything will be clarified in today's workshop. But in case you still have any query, reach out to us. And don't ask repeated question. Again and again, we all are telling this to you. Don't ask repeated question. Be attentive in today's workshop. You'll get everything, whatever you want to know. Amisha, you can continue.
Thank you. Just to add on to Deepti's point, I had queries regarding that on 24th March, we have written that we'll have matchups and draw of lots, so more or less the same thing. So basically, since you have been allotted one side, so of course there'll be an opponent. So if you're a petitioner, so you'll have a respondent as well. So on 24th March, you'll basically, let's say if your team code is 01, so you'll get to know who is your opponent, maybe 010, 05, it's randomly allotted. There is we just put up a random shuffle in the Excel sheet, and you will get your opponent. So that is what the draw of lots or the matchup means on 24th March. So you will know who will you be going up against. That's what it means. Also, like Deepti said, that you will be having questions from your written submissions. So there are just 3 points. Like, of course, it will be covered in the oral arguments. You first introduce yourself, you introduce your case. That's the next step. And then you have judicial interventions. That is what exactly like your oral arguments are structured in a way. Pratna and Shivani, they'll go into the depth of it and the skills and the mannerism of the oral advocacy. I hope this is clear. I'm still asking again, Harshita and Ekagrita, if there's any questions related to what happens in a moot court, I can address them right now. I don't think so there are, so I'll just go ahead. Okay, so next, basically the rounds. This was also a major question. So normally the standard, I cannot see the chat box, so if someone can help me with that, I'll be grateful. Okay, so basically the rounds, normally this is a standard procedure, but as I said earlier as well, competitions, they have their own regulations and they have their own rules and guidelines. So we have to read the rule book, but just to let you know what is the standard procedure of a moot court. So first you have preliminary rounds. There are 2 preliminary rounds, because when you go in an actual moot court competition, you prepare the memorials from both the sides. Please do not confuse yourself with CIM. CIM is just an intra that we are doing to get you inducted in the moot court society. But in the actual moot court, you prepare the memorials from both the side, like the petitioner as well as the respondent. And in preliminary round 1, you might be presenting one side, let's say petitioner, and in preliminary round 2, you may, let's say the other side, that is the respondent. For that, again, draw of lots and matchups happen. Randomly, teams are allotted that in round 1, you are the respondent and you will be up against XYZ team. Similarly, in round 2. So this is what a preliminary round looks like. So you are basically given a fair chance to present both your sides, to score marks from both the sides. And after preliminary rounds, top 16 teams with the highest score, the teams who have top 16 teams who have the highest score goes to the octafinals. And after octafinals, then we have quarterfinals and then semifinals and finals. This is how the moot court works. The rounds of the moot court works, and what happens, I've already told you. Moving on, just to summarize what exactly I have told in the last, and still I am getting a lot of questions after the proposition has been released about the research. So first, understand the subject matter. what is the subject matter of the mood problem. That is the most important aspect. If you understand what is the mood problem is related to, whether it's from criminal, consti, competition, IPR, whatever it is, first understand the area the mood problem has been given, what is the case related to. Once you have understood that, then you will be good to go with the research, of course. If you do not even know that this problem has, like, let's say some problems have more than one aspect, criminal and consti might be mixed in in some mood problems. So first break down your subject matter, and then a mood problem always gives you legal provisions. Like, when you are reading your facts, divide your facts into paragraphs and then pick out the legal provisions from those facts, and then research on that particular aspect. Just let's say, for an example, in there might be a right to privacy in in your research, so you know what article it is, pick out that legal provision and then research on that particular aspect. That will help you to go ahead, and then understand the concept of that right to privacy. What is right to privacy? What is right to be forgotten? If it's there in your mood problem, the legal provision you have picked out, understand the concept. Once you have understand the concept, then you will be able to relate it to your mood problem. You will be able to relate it to your present case. And once you have understand the concept, you have picked out the legal provisions. Okay, these are the articles, these are the sections that are used in my problem, and maybe these are the penal or more sections that I can use in my problem because it relates to that. You have understood the concept. Then you move on to the precedents and the similar cases. I've already told you in the last workshop that a mood problem always is based on a particular case that has been happened in the past. Some of the facts will definitely relate to that case. There is a similarity always. Of course, differences would be there, but once you find that similar case, it eases out for you. It helps you out a lot. That okay, this problem has been picked out from this particular case. So once I read this case, I actually know what contentions I can plead before the court, or what can I put in my memorial. So find precedents, find similar cases related to your mood problem. That is the next step. And
I would like to one thing over here. Don't go by the what was decided in that case, whether it was in favor of plaintiff or defendant. Just prepare your arguments. Even in Supreme Court, the judgments gets overruled, and many a times judgments changes. So it all depends on the advocate arguing the case. So don't go by the judgment, whether it was in favor of plaintiff or defendant or respondent, whatever it is. Just look at the contents of that case and the arguments that the lawyers presented in the court, and you can use the same and you can add your own apart from that to make your case strong. You can use both national and international aspects of it. Yes, Amisha, you can continue.
Thank you, Deepthi, for adding that. Yes, definitely, because as I said that yes, the facts might be similar, but there are differences. And let's say if you have used the whole case, your opponent will create difference in the court, that this case and the case, the precedent that has been used by my learned friend, there's a difference. They'll create the difference between them. So please make sure, like I told you, that the case you are using, every case which you're using in your memorial, what is the point that can backfire you, and what is the point from that particular case that you can use. And if it's a high court judgment, if it has been, like Deepthi said, if it has been overruled by Supreme Court, so that can be used by your opponent. So you have to be very careful while the cases, the precedents that you're using in your memorial. And of course, for the concept understanding, for better, basically, like there are case comments as well. So if you want to understand a case, maybe in brief, so you can go for research papers, you can go for commentaries, blogs, articles. There are a lot of blogs and articles written by top tier firms on a particular case or on a particular concept. So it basically eases you out to understand the concept. So you can go through that as well. Normally, for finding the cases and sometimes even articles and blogs, we use SSC and Manupatra. Astha and Karan will actually show you today how to use Manupatra and how to find cases on Manupatra. So it will be a bit easier for you. We already went through the Dewey library in the last workshop. So you know how to access SCC and Manupatra. And of course, the more you explore, the more you'll understand, okay, I can use this in my, like I can use this particular resource like this, because everyone has their own strengths and like strategies. So you can use the SCC and Manupatra according to your understanding. There is no set formula that, okay, I have to use the citations only, or I have to use the word phrases only. That's totally up to you. What is your ease at that? And then we have, of course, books. We have our LC2 library, even the central library. Even you can go into the CLC library. You cannot issue, but you can definitely go there and read. There are a lot of books, whatever topic you are preparing on, like let's say consti, go pick up the books, read that particular subject, read that particular legal provision. The books helps you a lot. And once you cite something from a book, it actually looks good in your memorial. Then you have LexisNexis, Hein Online, iPleaders. You can use all these websites. You want to note them down. You can do note them down, because I have been getting queries. What are the websites or the resources that we can use for a research? There are ample number of resources you can use. These are some of the resources that I use normally, so I just list them down. And of course, other executive members can also help you out with the resources. They can, once they are briefing, they'll tell you about more resources if they want to add on to. uh, that's all from my end. And then, of course, in the end, please do not forget that I have been repeating since the last time, that do not forget to relate it to your case. Just do not write, just do not do basically just copy paste and you have written a particular paragraph from a case or the precedent, or you have just picked up the article and has put in your memorial. Don't do that. Just understand it and write it according to your own understanding, and then relate it with your present case. Okay, why I have used this case and why I have used this article, because this is how it is basically used in my problem, my case. So relating it with your case, it is very important. Even in exams, we as students do this mistake, that we just write down that this is the case it is based on. Relate it, why I'm giving this a contention, why I'm pleading this before the court, why I'm using this precedent in my memorial, because it relates to my present case, like this. So these are the these are the basically a brief of how you basically do your research. And one thing, while doing your research, it is very important to create a bundle of yourself. So basically, bundle, it has your head notes, your arguments are written in brief. It helps you in the oral rounds. If while researching you put down a bundle, you put down your notes, it will help you in future. You do not have to go through everything again. So just keep making a bundle as well while you're researching. That's all from my end. If there are any queries, I'll quickly take them.
Yes, Sumit Daya is asking you to please explain the third point again, that is concept.
Okay, I'll just stop my screen first. So basically, concept is like, let's say, right to be forgotten. Just for an example, your mood problem somehow relates to or have a concept of right to be forgotten. And we as students do not know all the concepts. So for that, concept means just go and understand what is right to be forgotten. Go and read research papers on that. Go and read blogs on that, or maybe some commentaries might have been written, or some criticism, something might have been there definitely on the point of right to be forgotten. For an example, I'm sure some of you all know what is taxation, right? So there's a concept in taxation, grandfathering. When I was preparing for my tax moot, I didn't know what is grandfathering. So I have to understand the concept first of grandfathering. So that is what I meant by concept, that each particular word of your mood problem is very important for you. You have to understand the meaning of every single word in your mood problem, and then only you can proceed with your written submissions or draft your memorial. If you do not understand a word, if you just leave it, oh, this is not important, you're doing a mistake there, because that particular word might create a lot of impact on your memorial. You might miss out on a very important fact or a important legal provision of the case. Like just I said, grandfathering, I felt like this is a very simple word. But once I went into the concept of grandfathering, I understood that it's a very complicated concept of taxation. So that is what concept is. Can we cite Manupatra and SSC in a memorial? Yes, definitely. You can cite, you have to cite. So Karan and Astha will be showing you, I'm not sure if you have attended the past workshop, but we did show the memorial, how it looks like. And today it will be showed again. So in the index of authorities, you also mentioned what are the resources that you used for your to make your memorial, or from where you have cited these cases, paragraph, or anything. And even in the footnotes, that is what exactly citations are. That, okay, I've taken this case from, let's say, SSC, or I've taken this case from Manupatra or All India Report. So from where you have taken the case, from where you have taken the blog, you have to cite that in your footnotes. There are various citation styles that will be, Karan Nasu will go in the depth of that. Is there anything else that I can help with?
Amisha.
Alicia.
Okay.
I request Alicia to kindly share their queries in chat box only. Ekagrata, you may continue.
Amisha, there is a query regarding the bundle. So could you please elaborate about the bundle again?
Yeah, so by that I just meant that this is something that helps you in your oral round. So even in your while you're making your written submission, so when you're doing a research, just keep on making notes for yourself, like head notes. Okay, this is something that I found from here because once you leave it everything at the end, you have to go through everything all like from the scratch of it. So it's just that you are creating notes, like you're making your arguments. Just keep on writing down your arguments in brief. So once you are done with your memorial, you do not have to go through everything from the scratch. It will help you in the oral rounds. The bundle is just means that your research, your cases, your memorial, your compendium, everything, you just create a folder out of it. So everything is not scattered for you. It's in one place for you. That is the only thing of meaning by bundle. Please do not just go and with your compendium and memorial, because you have to write down your own notes. You have to write down your arguments in your own language. You cannot just go there and do verbatim. You cannot just read and speak out from your memorial. Don't do that. That is what exactly I mean by bundle. That make your notes, make your arguments by your own self, write them down apart from your memorial. Is there anything else? Okay, I just hope that now I will not get any queries related to research. And yes, one more thing before I end. Please do not ask us queries with respect to specifically to the mood problem. We cannot help you on that. We have to go silent on that as executive members. If there's anything which is in general you have a query, definitely we are there to help you. And there are a lot of queries regarding how to basically go for the oral round as well, which will Shivani and Nikagrita will definitely be covering. Shivani and Pratna will definitely be covering today. But in future, we will be conducting a lot of mock moods, intra moods for you people before you go for an actual mood court competition. Right now, we're just trying, our main aim is to basically help you with the CIM to get started at least. And so please don't worry and don't panic that I don't know at all, I'm clueless. Just try, because this is a process that you will learn with time, you'll grow with time. Randeep, if you could just please type it in the chat box. Kindly share a PDF of another memorial. This, as I said, I'll put the drive link in the description of the WhatsApp groups. The drive link has everything. That has your sample memorials as well. That has your mood problem. That has a citation style that you have to use, and that has the rule book and as well as the timeline. Everything is there in the drive. That is why I'm again and again repeating, please read the notices, the messages, the rule book, everything very clearly. We have been sending ample number of messages in the group, and I know it sometimes creates confusion, but please try to read the things that are in bold at least. They have the sample memorials. You can use that for your reference while basically to create a structure for your memorial. Is there anything else, guys? I think not. If there's, we will take it at the end. I would not take much time. Now I'll hand it over to Harshita again. Thank you so much, and best of luck for CIM. Good luck, guys.
Thank you, Amisha. Now it's time for second part of our workshop. For this, I would like to invite Karan, Thubani, and Astha for the drafting skills part. Both Karan and Astha have achieved a runner-up prize in 2022 with their teammate. Now, over to you, Astha and Karan.
Thank you so much, Harshita, and thank you so much, Amisha. I hope I'm audible to everyone.
Yes, you're audible, Astha.
Thank you so much for confirming that. Thank you so much, Deepti, Amisha, and Harshita, for all the things that you have shared till now. Now it's time that I take up. First, I would like to take up the importance of mooting, because I think that we have covered that in the previous sessions, like introduction and all, but I would like to cover this again so that people know that why they are here and how they can use the mooting skill in their CVs, and how they can enhance the skills, their skills, and how they can use the art of advocacy in their careers. So let me start. Can we go to the next slide? Yes. So first point is, why are moot courts important? So the importance of moot courts goes from networking to building confidence. So first, if you go on to if you go to different universities, different colleges to do moods. So the first thing that you do there is you meet new people, you meet new teams, you meet people from all over the world or all over the country. There are teams from NLUs, and there are people, there are judges from top tier professors from universities, top tier associates from top tier firms, top tier one firm, etc. So they can help you they can help you with every bit of what you are doing in this 3 years of your course. You can connect with them, you can ask them queries, you can also ask them for internships. If you have performed very well, you can also get internships from that. That is networking for you, and that is very, very, very important in your law school. Second one is that through moot courts, if you have done, for example, a moot court regarding constitution, and for example, you have done a criminal moot. So if you want to make a career, you want a job in a criminal sector with a firm, so that from that through that you can show that you have done research and you have an experience of drafting and the particular field that you are going into. Like for example, I wanted to go into the competition law. So if I have done most into the competition aspect, then I can show to get better internships. I can show that I have done very much good research through this mood, and I have achieved this position in the mood. And certificates of merit are very much considered in the internship process. Next is building confidence. I know that confidence is the aspect that everyone needs in the life, and you can achieve everything if you have a little bit of confidence in yourself that okay, I can do this. So that what helps, mood courts help you build that. If you are going to practice, mood courts are basically practice to get you into the real world and get you into the real courts. It teaches you teamwork, and that is very essential part as you work as an associate in the firm or you work independently. Everything goes with the teamwork. Either it's copying pages or either it's researching. Next is how to crack a moot court problem. That has been very much well explained by Amisha too. But now I would like to add upon that. That first you have to master the mood problem. If you have read the facts and if you have memorized the facts, like read the facts 4 to 5 times so that you can get a hold of what the prop is about, and you know how you're going to deal with it. Next is researching, that Amisha has told what are the resources, etc. And Manupatra and SSC will be covered by my teammate here, Karan Tubani. And next, refer to judgments, Supreme Court judgment, High Court judgment, etc. And foreign cases, academic material. First, you have to go to the library and cite the books, read the books. In the books, you may find cases very easily rather than going into the internet. That's what I have always preferred, to go to the books and go to the roots. So next, I would like to share upon. I would like to request Karan to let me share about the memorial drafting. I will come on the memorial drafting. That is parts of the memorial. Now I would like to show you a real memorial that we have drafted and the rules that we combine in order to achieve. It was a competition law draft, so I would like to show upon that now. May I? Is my screen visible to everyone?
Yes, it's visible, Astha.
Thank you so much. So this memorial is a respondent side memorial, and as you can see, this is the front page that is covered in red color. It was under section 53B of the Competition Act. This is the format that you should be using to have a clean and clear representation of your case. Next comes a table of contents. Table of contents is very important. As you can see that we have used to distinct between table of contents, abbreviations, like Roman numerals, and then we have taken up to so that we can differentiate between the arguments advanced and a table of contents. So then when you can cite your arguments that okay, this argument is present on page number 2, not the Roman numeral one. So that citations and that mentioning becomes easier, and it's become very clear to that these are the arguments and all. In many regulations and many rules too, it has become part that okay, these are the maximum number of pages that you can use for your arguments, so you have to keep in between so that you don't lose marks.
Asta, sorry to interrupt. Could you please zoom on your screen because students are not able to see? Yeah.
Is that okay?
Yeah. Zoom more.
Is that okay?
Yeah. Fine.
Yes. So next, I would like to come upon the next page, that is list of abbreviations. So if you are presenting your arguments, there are some parts and bits that you use as abbreviations like percentage, act, JV, etc. You can use this. You can make this a table, and then you can use this abbreviations in your memorial. For some memorials, it is compulsory to add the section and the page, and for some memorials, it is not asked. You have to check the rules and regulations for that so that you don't mistake it and you don't lose marks on the memorial aspect. Next is index of authorities, as Anisha also cited that you have to make a note of what cases you have cited. For example, what you have done. These are the cases that we have cited in the memorial itself. These are the distinction, online sources, and also about the citations. ILI citation style, one was asking that. The Karan will cover it in the extended form, but I'll just show what kind of citations you can use and how you can find them on the Google, so that you can take up help. And also, we'll mention the citation style PDF in the drive itself. So I would like to continue that these are the online sources. Like we have taken different online sources and different articles from that. Like for example, Mondak is an article, and government analysis, government journals, etc. That has been covered in the part of research covered by Amisha. Next is statutes, regulations. We have used combination regulations 2011. I know you won't be able to understand it as of now, but there are also statutes and regulations that you have mentioned. You have to mention in your memorial. Next is books and scholarly works. Like you can also always go to for help. Next is statement of jurisdiction. As you like if you are a petitioner or you are a parent, you should know that in what jurisdiction are you going to the court. So you have to mention that. For example, which section you are invoking to present your case in front of the court. So that is that here. Next, statement of facts. So you have to make a summary of the both sides. For example, petitioner, and there is a respondent. So for respondent side, if you want to, you can use a similar set of facts too, but it is preferable that you make the facts not very much. Do not mold the facts very much, but just make the facts relevant to your point. Like if you are a relevant side or on the respondent side, so then make the facts in that way that it is in your favor and not goes into the favor of the other party. So that's what statement of facts is all about. You can just get a hold, and also if you have to in the oral submission, it will be covered by Pratna and Shivani extensively, but I'm just telling a brief that in statement of facts, first of all, when you go into the oral round, it is not very prominent that you state statement of facts or not, but if you go into the petitioner side, statement of facts are cited and you have to say the statement of facts. So it is very preferable if you are very brief, very concise, and very precise with the statement of facts, because you won't have much time in the oral arguments. So just make them, understand them, and just summarize them into the way that you know what point is very important to mention and what point you should hide or not mention, etc. Then are the pages issues for consideration. This is the page in which you have to mention all the issues that you are considering in the present case. Then this is summary of arguments. Summary of arguments is like this is the issue, and you are summarizing your arguments, your legal arguments, into some very relevant and very basic thing and very much highlighted part, not the cases or not regulations and not the whole thing. You have to just mention your points. Like, okay, this is my point, was the question of law, this was the issue here, and this is my argument, and that I will cite. So that is what you have to do in this. And next, I would like to the arguments advanced. The arguments advanced will be covered by Karan Tobani. I would like to hand over to him the next technical part of this submission. And I would like to thank you all for listening to me. And I hope I did not bore you. And I shared the information very in a correct and precise manner. And thank you so much for that. I would like to hand over this to Karan Tobani. Thank you.
Thank you, Astha. I'll share my screen just a moment. So starting from where Astha left. So for drafting, we have to make sure that, am I audible?
Yes,
Yes,
you are
you're
audible,
audible.
Karan.
I just thought I was on mute. Huh. So for rules of drafting, you have to ensure that you read the rules of drafting for a moot court competition you are appearing. So the rules are somewhat different. They're not very different in each competition, but they are somewhat different, and it differs from competition to competition. So for now, if we are concerned about just the CIM, then at the end of this workshop, we'll also discuss the rule book of CIM with you. So you have to make sure that you read the rules that are mentioned in the rule book and strictly adhere to that. So for CIM, let's say we do not have any negative penalties for that, but in a moot court competition, there are negative marking for that as well if you are not following the proper rules of drafting. There are also page limits per section of the memorial. So for example, generally for the statement of facts, for the summary of facts, you can use maximum 2 pages. If your summary extends beyond 2 pages, yeah, a negative you will be marked negatively. Same applies for arguments advanced as well. So it depends from competition to competition. Then I would like to focus on how do you structure your memorial. So follow this rule, IRAC, that is issue, rule of law, argument, and conclusion. So the first of all, identify what the issue before you is in that moot proposition. Identify that issue, list down that issue, and then you have to find what rule of law, what provision are applicable here, what case laws are applicable here, what precedents you may use here. And then it is also advisable to create sub issues. So there is one main issue, and then you can create some sub issues that would be really helpful, not just for you during the oral arguments to present, but it will also create a good impression on the judges whenever your memorials are judged, or whenever the judges listening to your oral arguments, you can refer to the sub issues quickly. Then so argument, you have to, so there are two ways to approach to an issue. So one is you find all the relevant cases and the provisions which are applicable for that issue, and the other is so it's not that you have to have so many judicial precedents to have a strong argument. You can just have a few, let's say one or two judicial precedents mentioned in your memorial, but what you have to do is you have to form your argument on the basis of that judicial precedent, that why that particular case law, why that particular judgment is relevant in your case, in your issue, and how that can be how that ratio can be implemented here as well. So you should be aware about the facts of that case. Not all, I mean, it's not possible to be aware of facts of each and every case you're mentioning, but you should be aware that what was the ratio in this case, and then you conclude that issue accordingly. Now, as far as the citations are concerned, so there are different kinds of citations. There is ILI, there is Blue Book citation, there is OSCOLA, but for the CIM purpose, you are supposed to follow the ILI citation style, which will be doing it in just a few minutes from now. So as far as the resources are concerned, I think this is briefly covered by Amisha and Anmol in the previous workshop as well. There is SCC Manupatra. Also, there was this query in the chat box I was reading, that how do you access SCC Manupatra through DOE library? So we'll do that again right now. I'll show you. Let's just move on to that for now. So log on to duelibrary.in. I hope you all have received your institutional IDs. So you have to ensure that you log in here using your institutional ID only. So I'm here already logged in. I'll log out once. Click on login. Click on login with the official account and click your institutional ID from here. And then you will be logged in. It's as simple. Go to e-resources, go to by format section, and then there's this remote access databases. Click on that. So here there's Manupatra. There are so many databases. Like for now, if we are just focusing on SCM, then SSC and Manupatra would be enough for you guys at this point. So let's start with SSC Online. Click on read. Click on login. Now here, if you are on user login tab, just go to IP log here and enter your institutional ID. And that's it, you're logged in. But you have to ensure that you use your institutional ID, otherwise you won't be able to log in. So now here there are so many ways through which you can find a case law. For example, let's start with find case law by section. Let's start with Competition Act, let's say. So here you have all the sections of the Competition Act. Let's say section 20. I want to find the case laws related to section 20, or let's say section 5. So I just have to click on that particular section. First enter the act name here, select from the options. Then click on this section you want to find the case law on, and then simply click on go. So now you will find all the notes, judgments, acts, and all the legal business news here regarding it. Now, let's say we just want to focus on the judgments. So just remove these options. And then you have 162 judgments on this particular section only. So that's how you find case laws by section. Then by citation, sometimes what may happen is you have a citation of a particular case, but you need a copy of the judgment. You need to go into the details. So here, not only the SCC, but there are a number of citations available here. Let's say if we want to find, let's say SCC kai judgment, then you have to enter the citation here. So here I'm writing it randomly. Let's say 2004 one SCC 1 ka case. This is a random citation I'm trying here. So here we have the judgment. So this citation belongs to this judgment, State of UP and others versus Lalji Tandon. So you'll have the whole judgment here. If you want to, I don't know whether this is covered in the previous workshop or not. If you want to print the whole judgment, you just have to explore the options here. You can see the print option here and click on print. And here you have the full judgment downloaded. Now that being done, let's focus on Manupatra as well. So there are same way you can find also moot court resources. If you many of them were asking questions about where do they find sample memorials. Though we have already shared sample memorials with you on Drive, But if you really want to refer to moot court resources, it's on SCC, it's a great tool. Just on the dashboard, go to moot court resources, and here you will find n number of sample memorials of various moot court competitions that are held annually. So you can just click on any moot court competition, and then you'll have the memorials. Now let's focus on Manupatra. So same way, from the remote databases section, there will be Manupatra. Click on read, and here click on IP users, and then you will be logged in. So here there's a tool called Manu Search. Click on that. And
Karan, there is a query that can we make a hypothetical cases?
No, you cannot make hypothetical cases. You have to strictly rely on the judgments which are already pronounced. Also, let's say if there is a case which is a high court has pronounced a judgment on it, but it is under consideration by Supreme Court, then you cannot cite that judgment. I mean, that may go against you, because if the judge is aware about that this case is particularly in the Supreme Court at this point, then that does not hold any value. Even the opposite counsel can say that this case cannot be used here because this is already under consideration by the Supreme Court. So no hypothetical cases, no cases which are already under consideration by the court, and also no cases which are overruled already. So if you are, let's say there is a high court judgment and that has been overruled by the Supreme Court, you cannot use that high court judgment, because once the Supreme Court has laid down a rule, then you have to only use that. So now here again we are on Manu Search. Similarly, you can search here as well. Either you can search from title, you can search from citation. Again, you have to, if you have the citation, you have to type your citation here, and then the case will be displayed to you. The other way of searching on Manupatra is, though it is not relevant for you for the CIM purpose at least, but this will help you when you appear for other moot court competitions. So here, if you know the party names, then you just type the appellant or the respondent name. Whatever information is available, you just have to type it here. And then you have to just click on search, and then you'll have the judgment with you. For specific, so this there are also specific remote access databases for let's say there is a corporate law advisor where you can find cases related to corporate law specifically, and also research papers and other things specifically related to corporate law only. So there are so many databases which you can use. There's Hein Online Access also available, so you can use that so just explore this DOE library as much as you can. You will find lots of materials which can be useful. Now moving on to the citation part. Someone was asking that how to make a citation. So what I'll do is I'll just open a sample memorial which I've prepared, and then I'll try to show you practically how to do citations. So let me open. So let's say here is the case which I've cited in my memorial of Delhi Vyapar Mahasangh versus Flipkart. This is not related to your CIM, so don't confuse. This is just a different memorial.
Karan, please zoom.
Yeah, zoom. Okay. Is it fine?
Yes.
Okay. So here, for example, I've mentioned this case of Delhi Vyapar Mahasangh versus Flipkart. So let me show you from the beginning how to do it. Let's say here I have typed. So generally you bold the case name, whatever you have cited. Okay? And now you go to references section on in Word and then click on insert footnote. So if you see here, a footnote will be created here at the bottom of the page, and then you write the case name again and write the citation. So here you can type the citation. Now
Ria
what?
Amra is asking what citation style you have used here.
So here the citation style used here was Blue Book, not the ILI. So let me also open the ILI style and show it to you. So this is the ILI style you have to follow for CIM, right? So let's say here for let me open a memorial where I have followed ILI style. Let me open my CIM memorial only. I don't remember. So yes, also one more thing you need to focus on
Karan,
is
please zoom little
yeah,
bit.
yeah. Is it fine now?
Yes.
Okay, thank you. So yeah, I have followed ILI style. So for example, here I had cited a case of Pratibha Rani versus Suraj Kumar and another. So so for example, this is the paragraph I had cited from the judgment itself. So also, yeah, this is also which you need to keep in mind that sometimes if you are citing verbatim, if you're copying a paragraph verbatim from a judgment, it is you have to put it in the inverted commas, and then after the inverted commas, just click on insert footnote, go to references, insert footnote, and then here a footnote will be created automatically. The numbering will also be done automatically by the system, so that is not something you should be worried about. And then just type the case name from where you have.
Koli Tanuja is asking, can we cite foreign judgments?
Yeah, you can cite foreign judgments, but it depends. So it depends from case to case basis. Sometimes it has good persuasive value, sometimes it does not have. So, for example, let's say a case is related to competition law. So our competition law is mainly based on the UK competition law. So you can cite it, and it so it sometimes in the moot proposition also it is mentioned that the foreign judgments of this particular jurisdictions have high persuasive value in this court. So you can use it, but it has limited persuasive value. It depends from case to case basis. So here, as the footnote is created, you just type the case name, write the citation, and that's how you're done with it. If you're citing it from, let's say here I've cited a few things from a book. So if you look at the citation number 2, here I've cited from the Sir Gurudas Banerjee's book on Hindu law of marriage and Stridhan, and this is the paragraph I've cited verbatim from it. So hence again I've put it in the noted commas, added the footnote there, and here in the footnote I've mentioned the author name, the book name in the italics as per the citation style you have to follow. So in ILA you have to follow this, then the page number and the publication name and the year of publication. So now, do you have any queries
Yes,
regarding citation?
Randeep Punia is asking what is the difference between Blue Book and ILI?
So these are just different citation styles. Uh, Let me show you. So here on your screen, currently you can see the ILS citation style, which you have with you right now as well. Let me just show you for your reference, though it is not relevant for you at this point. But for your reference, I'll just show you what the Blue Book citation is. So here is the Blue Book citation style. So it's these are just ways of citing the material you have used, the cases, the books, the research papers, whatever you have cited. It's just a way of citation, nothing more than that. So different competitions have different citation styles. They have mentioned they'll mention it in their rule book. So you have to follow the rule book and use it accordingly. So for now, because you are preparing for CM at this point, so we are just focusing on the ILI citation style. Otherwise, it's just simple. So for example, they've mentioned here how to cite a statute according to Blue Book. So you just have to follow that citation style.
Ritesh Pathak is asking in the section of authorities where we mention case laws, how to add on page numbers on which that case laws are mentioned.
Okay.
You have to refer CIM rulebook.
No, so I mean, you have to in the index of authorities, you have to mention the cases and the page number. Wait, I'll just go on to that page. Yeah, here. So this is the index of authorities. Also, make sure that you divide the index of authorities into different sections. So the case laws in one section, the books referred in a different section, the statutes you have referred in a different section, and if you have referred any research papers or online sources, then that can also be added in a different section. So yeah, page number, about the page number, you can simply write the case name, and I think it's not a big task. You can manually do it. It's simple because you just have to write the case name and then add the, so generally what I follow is I start with the arguments advanced section. So I mean differently, it works differently for different people, but so I start with arguments advanced, because that is the main part, that is where your main arguments are. The starting pages, that is the cover page, the summary of arguments, abbreviations, index, this is all you can do it in the end, because those are just the cosmetic pages. So, and statement of jurisdiction. So because once the argument advanced section is created, you'll know the page numbers, and when you create it in the end, you just have to cross reference it. So it's not a big task, you can do it in the end. Anything else we have?
Priyanshu Gupta is asking how to access this e-library for getting the access of SSC.
Okay, I'll tell you one more time. So log on to duelibrary.in. I mean, if you are joining from laptop, you can use it you can try side by side as well, or it also works on phone as well up to an extent. So log on to duelibrary.in. Just put the URL in the chat box, Harshita, if you can. Like, I mean, if they don't have it, wait, I'll do it. Just log on to duelibrary.in. Log in here using your DU institutional ID only. I hope you all have access to it by now. Just click on login, click on login with DU official account, and click on your institutional ID. And you'll be logged in. Go to e-resources section. In the by format section, there will be remote access databases. Click on that. And here you will have all the remote databases available. So here, just scroll down a bit, and then you'll find SCC online here. And Manupatra is also here. and there are so many other databases as well which you can explore at later stage, but at this point I think this should be sufficient. Any else?
Karan,
Yeah.
there are few questions on jurisdiction. So could you please elaborate, like what
Okay.
is
Okay.
jurisdiction?
Sure. Sure. So, for example, let me open my recent memorial I had prepared on competition law. So, for example, this is the statement of jurisdiction for that particular moot proposition. So, statement of jurisdiction is basically under which jurisdiction you are appearing before the court. So what provision gives you a right? What gives you locus standi before this court? That is simply statement of jurisdiction. So, for example, here it was a competition law case which was presented before the NCLAT. So the Section 53B of the Competition Act gave them the locus standi to appear before the court and raise a petition. So you simply have to mention that agreed by the order dated on 15th October. So uh, because of this order, they have appeared, they have petitioned in the NCLAT under Section 53B, and then you have to reproduce that section here. So it is not necessary that you reproduce whole section here. You can also just reproduce the relevant subsections of that section here. So section 53B and the subsections which are relevant, you can just simply reproduce it here. It's as simple as that. This is for the appellants. Now for the respondents, you have to make sure that, let me now open a statement of jurisdiction for respondent, because it is appellant who comes to the court under a particular section. But here, let's say the respondent was the competition commission, right? So here, so generally the jurisdiction for respondent is that because the appellant has invoked section 53B of the Competition Act, and they've preferred an appeal before CCK, before NCLAT, and hence the respondent is here appearing in the said matter. So generally for respondent, it is because the appellant has invoked this particular jurisdiction, we are appearing in response to that. For respondent, that is the statement of jurisdiction. Any other queries we have?
No, many some queries are related to the clearly drafting part. So for that, they have to refer to the CIM rules. And
Asha, so
one query is about the real case and cases they can, as Jitu Mohan have asked, as said, every mood problem is a real life case. Can I use the real life case judgment in the mood problem? You have to use the real life cases only.
yeah.
Please elaborate if you want to, Karan.
So as far as the queries regarding CIM rules are concerned, so after this workshop, we'll be just having a quick session about the CIM rulebook as well. We'll just read out all the rules to you and explain all the rules to you briefly. So if you have any queries regarding the CIM rules, just wait till the end of this workshop, because now the oral arguments workshop will be covered by Prarthana and Shivani, and after that we'll cover the CIM rules as well. So, Harshita, Ekagrata, do we have any questions regarding the drafting part as of now?
Let me check it again here. Ekagrata is taking care of the YouTube doubts.
No, I don't think any questions are there on the
No.
YouTube chat.
Okay. No specific drafting queries. There were, but I think Amisha have answered all the queries in chat box only. So no other query.
There's this question: is it okay to make certain mistakes while drafting our memorial? I mean, yeah, we do make mistakes while drafting. So you can just, what you can do is you can you can go through it as many times as you can, but then yeah, you can make mistakes. Yeah. but then let's say for the competitions, there will be negative markings for the same. So for example, if you cross the limits of number of pages, let's say for arguments advanced, uh, there are the limit is 25 pages, right? So for example, then you will have to adhere to that. If you cross the number of pages which are mentioned, then you will be negatively marked for the same. Also for the citation, one thing I forgot to mention is that you have to ensure that you follow the font size and font as well. So for I'll just share my screen again. So, for example, generally the size of font is bigger for the main text for the arguments, and for citation it is a little smaller. Also, there is paragraph spacing which you need to focus on. So, for example, this is an argument, right? So the font size here, the font is Times New Roman, the size is 12. The alignment has to be justified, and the spacing has to be, so it depends from competition to competition. This competition asked us that the spacing has to be 2.0, so we have kept it 2.0. It could be 1.5 as well, so just follow whatever the rules says, right? And for the citation, select the citation. The font has to be Times New Roman. The size depends, again, they also give you the font size for everything, so you have to read the rules again and again and follow it. So, for example, they had asked us 12 for this for the citations as well, but generally it is 10. So keep whatever the rules have asked. The alignment has to be justified here as well, and the line spacing has to be 1.51 or whatever they have asked.
Sumit Daya is asking, what is the meaning of justify?
These are just different alignment styles. For example, I've selected a paragraph. So this is align left. So here the text will be aligned to left. This is center, it will be aligned to center. This is aligned right, so the text will be aligned towards right. And this is justified, so it is justified. Uniform. That's it. Anything else?
Not at this platform, but let us wait for
Okay.
1 minute.
Karan, can you also suggest like the sites we have available for free? Because some people are saying that they cannot access the DUE library as of yet through their institutional IDs.
Is it? So I don't know, maybe
They need to send the email to the central library. That
no.
email they will get in front of the central library, or we will share that in the group. They can email them, and within a week they will get the access.
Or yeah, just contact the admin office once and ask them what is the issue. But generally by now, because the half of the semester is already over, so you should have the access by now. Just check with the administration once. We'll also try to see what we can do for that. Just we'll inform you in the group. About the different websites which are available. So here, just click on the remote access database, and here you have this database is available. There are so many journals, and then you can use it. You just explore it. It is not relevant for you at this point for the CIM purpose. Just stick to SCC and Manupatra for now. But if you want to access any research papers, let's say, which could be useful for you, then EBSCO, this EBSCO is also useful. You can use that as well. Yeah, simply you have to write a query which you need to find a research paper on, and just click on search. Anything else we have for drafting? Otherwise, what we'll do is after the oral section is covered, we'll again take up queries if they're left, and we'll go through it. Okay, so Hardik is asking, SCC or Manupatra mentions overruled cases, or we need to cross verify separately. So here generally there are let me show you here only. So generally, the case notes are mentioned here, and in the starting, it is so whenever you will start reading a case, you will know whether this is an appeal arising from a high court, or whether the Supreme Court has taken a suo motu cognizance, or whether the appeal has been raised to the Supreme Court or not. You'll get to know by reading the case itself. Otherwise, let's just find a case and try. I'll just open a random case. So here you will find the case history in the first introductory paragraph, which will say that whether first the case was raised in the district court, then it went to the high court, and then it has came before the Supreme Court. So you'll find it by the introductory paragraph only. If not, just a simple Google search will also help you here. Anything else?
Karan, if you could just elaborate people on the memorial pages, there have been a lot of questions regarding that for the CIM.
Memorial pages, like the different parts of the memorial. Okay.
No, as in like their questions. I know you'll take the rule book later, but just explain them that like the number of pages that are required, like for a
Okay.
particular section.
Okay, so let me just refer to the memorial section of the rule book at this point. Then we'll cover the rule book in detail at the end of the session.
Can you just go back on the drive, please, once?
Yeah, here I am.
Yeah, since a lot of you are asking that where we can access everything, so this is the drive that has been shared in the notice. And again, today we'll put up a notice for the allotment of sites. So the folder is there for the sites allotment as well. There are two PDFs in that are first year and second year. So you can find your name and the site that has been allotted to you. And everything is there in this particular drive. Today's workshop resources will also be uploaded, and your mood problem, your rule book, your citation style, everything is there. So I hope this solves your query regarding to the how we can access the drive. This drive is accessible to all. You just need the link, which is there circulated everywhere. We'll put it on the groups and in the description as well. Thank you, Karan. You can go ahead.
Okay. Also, I hope everyone is aware about the timeline that they have to submit the memorials by 21st. Now about the, yeah, so here is the format of memorials. So the main text has to be, as I was mentioning while explaining the from the memorial, that the font and the size and spacing you have to follow as per the rule book. So for example, here for CIM, the style has to be Times New Roman, the font size has to be 12, the line spacing has to be 1.5, and the alignment has to be justified. For the footnotes, the style has to be Times New Roman, the size has to be 10, line spacing 1, and alignment has to be justified. For margins, there has to be a default margin of 2.4 cm or 1 inches on all sides of the page. Now, for the cover page of the memorial shall be colored blue for petitioners and red for respondents. Let me, for your reference, show you the cover page. Yeah, so for a petitioner, the color has to be blue. If the side allotted to you is petitioner or appellant side, then the only the first page has to be blue. Please note that all the other pages have to be simple white pages. Only the first page has to be blue, and for the respondent, it has to be red. The first page, like this. So I'll keep this open and explain you. Right. So yes, in the cover page, your team code has to be mentioned. The codes will be allotted to you by tomorrow latest. We'll try to do it by today itself. And so your code has to be mentioned here. You do not have to mention your name, your anything which identifies you should not be mentioned on the memorial, not on the cover page as well. So here you have to mention your code, then name of the forum before which the proceedings are conducted. Here, the proceedings are conducted before the National Company Law Tribunal, Appellate Tribunal. For this was the cover page. So here you have to write it upon submission to the Honorable National Company Law Appellate Tribunal. You have to write your code name here, whatever applies to you for CIM. Year of competition, here you have to mention this was the 12th Island UNT Trust Moot 2023. Name of the case, there are different ways of mentioning this. Either you can follow this or follow what has been displayed in the sample memorials. And title of the memorial for petitioner or memorial for respondent. Now for the table of contents, the so abbreviations whichever you have used. Let me just show you the page of abbreviations once. So here, whatever abbreviations you have used throughout your memorial, you have to make a table for abbreviations, and you have to ensure that all of them are listed here, even the smallest abbreviations which you may have used. But you have to follow that the table of abbreviations should not exceed more than one page. So you have to ensure that the all the abbreviations are mentioned on the single page only. Acha, do we have the page limits for abbreviations? I think we have not mentioned here. So maybe for CM you do not have to follow this, but generally for the moot court competitions you have to. Then there are index of authorities. So all the authorities which I've already showed you once, authorities, cases, whatever you have cited, has to be mentioned in the index of authorities, all the articles, whatever you have mentioned. Then comes the statement of jurisdiction, which I've already explained. Statement of facts, you have to summarize your the moot proposition, the case here. So here you have to ensure that you do not have to write your arguments here in the statement of facts. You just have to summarize the moot proposition here. Like for CIM, this time you have a very short moot proposition anyways. So you just have to create a short summary of that, and you have to write it in the statement of facts. Then comes the issues for consideration. So you have to frame as many issues as you can. Generally, 4 to 5 issues are advisable at max. Then you can create sub issues. Don't create more issues. Don't create like 7 to 8 main issues. Create 4 issues, main issues, and then create sub issues to it if you have any more issues which you can create. And then here in the summary of arguments, you have to summarize your arguments. So for example, the summary of argument 1 of issue 1 has to be summarized here in few lines. For issue 2 similarly, for issue 3, and for issue 4 similarly. So for example, here for CIM purposes, you have to follow the page limit for statement of facts. If you read rule 7.14, here you have maximum 2 pages for the statement of facts. Same goes for the summary of arguments. You only have 2 pages. Issues raised, it's just a single page. And then arguments advanced in prayer. So I have not shown you prayer, right? I'll just show. So let's say here we have started with the arguments advanced, and in the end there is prayer. So so including for CIM you have limit of 15 pages, right? So in 15 pages you have to ensure that arguments advanced and prayer are also completed. So prayer is generally 1 page, so you have 14 pages for arguments advanced. So this is how a prayer looks like. So in prayer, basically you have to mention what you are exactly demanding, what you are exactly asking or praying before the court, what you are seeking, what relief you are seeking from the court. That has to be mentioned in the prayer. For marking of the memorial, see here we do have negative marking as well. And so for marking of memorials, these are the parameters, these are the penalties. So if you are not using the current font size, or the line spacing or the alignment is not as as what has been asked in the rule book, then for 1 mark for every page will be deducted. If any of the sections you may have missed, or the order of the section is not correct. So for example, you have mentioned statement of jurisdiction afterwards, and you have started with the summary of arguments first, then there will be negative marking for that. Then if the citation style is not used correctly, then 1 mark for every violation. Then incorrect page size, page margins, 1 mark for that. And on the cover page, if you have not mentioned what details, what we have asked here, we have already mentioned what needs to be on the cover page, then that has to be, then there will be negative marking for that as well. And yeah, if you are exceeding page limits, 3 marks for every page will be deducted. So make sure you adhere to the page limits and the formatting styles which have been mentioned in the rule book. That's it. I think the memorial section is covered here. We'll cover the remaining rules for the CIM after the oral arguments are
Karan, just a second. I need to pitch in few things here. Can you just go back to the rule book?
sure.
Okay, just to clarify some of the messages I've got on my DMs. So memorial submission is an online process. So we'll be provide. There's a link that is already there in the rule book. So you have to. Can you show the yeah? So in this link, you have to provide your memorial in two formats: the Word doc as well as the PDF format. It is written in the yes doc format and the PDF format. Both the formats have to be submitted. Then someone has asked me that like in the sample memorial it is written names third national moot court competition. So in this you have to write CIM 2023 because that's the name of the moot court competition, just for an example or a parallelism to be drawn. So I hope this answers your query. Then just a second, I have some other queries as well. Yeah, for the anonymity, please make sure that you do not write your name in the memorial anywhere, because if we find that a name is your name has been written in your memorial, you will be straight away disqualified. This has to be strictly followed. It is written in the memorial. Karan was just showing. It is written in the rule book, which Karan was actually showing you right now. So please make sure that you do that. Do we have to submit memorials in both? Yes, you have to submit your memorials in the PDF as well as in the doc format. It is written and it is given in the format as well, in the Google form as well, which Karan just showed you. Okay, and someone has asked me, Karan, if you could just show them. I just want this to get done before the oral rounds. That some of them is not able to log in into SCC because they have not registered. So before we actually use our DUE library to go to SCC and use IP login, we have to register on SCC. So if that is something that you can show them, please.
I think I'll have to try, because since my ID is already registered, so I don't know how do I show it to them. I think for registration, you just have to enter your institutional ID as well. Even for the IP login, you just have to enter your institutional ID and then you will be registered. I don't think that should be any issue. Just ensure that you are entering your institutional ID correctly. That's it. I think because you just have to do it once, you just have to enter your institutional ID once, and then you'll be able to log in. Because since my ID is already registered, so I can't show you how to register at this point.
Yeah, but where do I register? I access DUE right through the institutional ID provided, and then Manupatra is yeah, Manupatra directly lets you to log in through your IP, but on SCC you have to register first. So like there's an option of registration. I'm not sure like how to tell you that. Yeah, right. Register here written at the bottom. So you have to put your DUE email ID and your full name, and you'll get registered. And then you go back to DUE library. From there you can use the IP login then.
Also guys, one more thing, that you have to access the SCC link or the Manupatra link through DUE library only. If you'll open it on your browser apart from DUE library, you'll just Google it SCC or Manupatra, you won't be able to use it. You have to click on the links given on the DUE library only, then only you'll be able to access it. because it is through IP. So I think this is clear now. Anything else we have, Harshita or Ekagrita, regarding drafting, or shall we move on to oral rounds now?
Yes, not on this platform. So let's wait for Ekagrita. Ekagrita, is there any query on the YouTube chat box?
No, no, not yet. I think you have answered all. Then we can take up later if there are any more queries.
So let's proceed with our third part of our workshop. So now it's time for oral skills, and for this we have two speakers, and both of them have achieved a Best Mooter Award. Prantananda have achieved a national Mooter Award in National International Arbitration Moot Court Competition, and Shivani Sherawat won the Best Mooter Award in Vidya National Moot Court Competition 2022. So don't lose this opportunity. Ask as many questions as you can from them and listen to them very carefully. Over to you, Prantna and Shivani.
Thank you so much, Harsh, for that lovely introduction. I'd just like to ask if I'm audible properly and also visible. Can you just give me a thumbs up?
Yes, you're audible, and the screen sharing is also clear.
All right, perfect. So, Shivani, could you move to the next slide, please? Yes. So, see, now that you're through with, and Karan took a lot of doubts, I really got to give him that. So now that you're through with all that is required to research for a moot court, I'll take you through what is considered perhaps the most challenging part of a moot court, which is the arguments. Now, no matter how good of a researcher you are or how unique and solid your points are, if you aren't able to present them properly, it's all a waste because nobody will realize what you have researched. And in every moot court that I have participated in, the oral arguments always have a better more weightage than your memorial. It could be the same, but it is never less than the memorial. So be very particular about what you say while you're going for your oral submissions, because your oral arguments, they are like a make or break of a moot court. And I'm just not talking from a CIM perspective, but in general. So I'll take you through certain steps. I've mentioned 8 steps over here. And the first, and this is probably the most unaddressed part of your oral submissions, which is the preparation. So see, when you go for an intra-college moot court, or an inter-college moot court, so there is always a team that you form. That team consists of either of 2 people or of 3 people. Usually it's a 3 people team where one person is a researcher and the rest 2 are the speakers. Now, what usually happens with beginner mooters is that the researcher does all the research, he or she drafts the arguments, he or she makes the memo, and the memo is submitted. After that, what the speakers do is they just pick up points from that particular memo and they don't do any further research and they just go and start giving their arguments. Now, this is a major blunder that you do from the very beginning of your preparation, is that you're not researching properly. Just because you are the speaker does not mean that you will just spoon feed whatever the researcher has prepared for you. You as a speaker should know as much as the researcher of your team does. Because see, when you go before a judge, the researcher is not there to spoon feed you, or by the time they answer your queries with regards to something or with regards to a judgment, just like somebody had a query with regards to a particular judgment being overturned. So at that particular moment, when you're inside the courtroom, nobody is going to tell you if that particular judgment has been overturned or it has been referred to the higher bench of the Supreme Court or something like that. You have to have that knowledge yourself to be able to answer all these questions. So that part is there. The second part involves starting strong. So for those of you who were involved in public speaking in your school and undergraduate level, you must have heard this very common term that you should always have a very catchy starting to your speech and a very catchy ending. So in moot court, what people say is that moot court is a very formal process and we should steer clear of all the rhetorics, etc. But there is always an opportunity to slide in a few rhetorics here and there, and trust me, they really help you. So let me give you an example. Let's say there is person A, and person A comes to the courtroom, he or she starts it
very normally, like the usual courtroom language. May it please the court, the counsel seeks permission to state the facts of the case. Now, this introduction is not wrong per se. You will not lose marks for saying just this. It is acceptable. But then person B comes, and person B goes, your lordships, the issue before us today is not a mere issue of facts or damages. The matter today involves a serious question of law, a question of justice, and I have utmost faith that this bench, along with the legalities, will also take into consideration justice, equity, and good conscience while announcing the verdict. May it please the court, the counsel petitioners in this case of X versus Y seeks permission from this honorable bench to proceed with the facts very briefly. Now, this introduction will not give you essentially any brownie points for, saying all that. But what it does is it catches the attention of your judge. And if you have a well-researched argument, you trust me, you need the attention of your judge, because without that, it's human mind that, keeps going around here and there, and the judge may not listen to all the arguments of yours, and the whole process would be wasted if the judge doesn't listen to you. So the first goal as a mooter of yours is to attract the judge's attention in any way possible. So you may add any legal rhetoric, etc. Whatever you find, just be creative with it. Don't be a little too informal, because it's a courtroom, it's not a normal debate. Which brings me to my third point, which is clarity. Now, what happens is that as I see a lot of my juniors also making this mistake, that whenever they're being asked to present the facts, what they'll do is that they'll open the moot proposition and they'll just start reading out the facts, A to Z, whatever comma, full stop also they won't leave. So they'll just start reading out the facts as they are from that moot proposition itself. That is a major blunder, and it really ruins your impression in front of the judge. You should not read out anything. And as Astha also said during her session, that your facts should be molded as per your party's interest. You do not have to say everything that is presented in that particular proposition. That proposition is developed, it's drafted in such a way that it caters to both the parties' needs, that some facts are in favor of one party, some facts are in the favor of other parties. So you have to make sure that whatever facts you present in front of your judge, especially while oral arguments, they have to be very crisp, they have to be very to the point, and they have to support your interest, because every second that you spend inside the courtroom should go into your favor. You should not waste even one moment talking about things that are not relevant to your particular case. So that is there. Next thing, let's talk about the body language. Now, from body language, for people who are into debating and public speaking, you know how important body language is. But the body language that we talk about inside a courtroom is very, very different from the body language that you use, let's say, while having an informal conversation or maybe even a formal debate. I remember one of my experiences where I was with my I was with my co-mooter, and that person was a very eloquent debater, and he was too good with his arguments. But the moment he started doing something like this, he started raising his fingers at the judge. The judge put it out, he stopped him right then and there, and his marks were deducted. So make sure that whatever body language you take inside the courtroom has to be of a lawyer. You are not going there as a layman or a student. You are going there as an advocate, as a lawyer, and you respect the sanctity and the dignity of the judiciary. So you take note of all of that, all of those things. Next point, let's talk about keeping it simple. So keeping it simple is just that you should not be saying any word that you don't know much about. Let's say that you used a jargon or a legal term that you may not have much of an idea about. What happens there is, if the judge knows about that particular jargon, that particular legal term, they will fixate their attention over you, and they'll grill you over it because you use that word in a very in an irresponsible sense. So that is something that you need to take care of. Then moving on to the questions part. Questions see, the questions can be asked at any stage. They can ask questions in the beginning also, they can ask questions at the end also. The judge is free to question you wherever he or she thinks is appropriate. So usually whenever you enter into a courtroom, the judge starts by questioning you on your jurisdiction, that still, why are you here, what makes you think that this is the right court, why should we listen to your case, you could have gone there, you could have gone to this court. You need to know the jurisdiction very clearly in order to justify why you are standing at the court and why you are presenting that case before the court, and why should they listen to your arguments. So this is one mistake that people make, is that they don't really read up on the jurisdiction, and they don't really know the provisions that go into deciding the jurisdictions. And about questions, so there are usually three types of questions. The one to which you know the answer to. So if you know the answer, obviously you answer it with utmost confidence. Second part is where you don't know anything with regards to whatever the question is, where you don't know the answer. Don't go circles around the question, because the judge knows if you know the answer or not. They can just tell in a fraction of seconds whether you know the answer to the question or not. So just politely say that the counsel pleads ignorance, or that the counsel would take like a later time to read upon on that particular issue. The third type of question is where you know a little something about that particular issue, but you don't know much about it. In that case, you mention whatever you know about the question, and you just plainly state that the council needs further time to read upon this particular matter and stuff. Basically, you need to be creative with how you present yourself in a courtroom, because these count as courtroom etiquettes, and these are court crafts. And the better your court craft is, court craft also carries a significant amount of mark in your oral arguments. So if your court craft is not good, your arguments might be good. If your court craft is not good, you'll lose around 5 to 10 marks. Or there are some moot courts where court craft alone consists of 15 to 20 marks. So just assess the importance of what you are saying, how presenting yourself, and how to go about the particular phase. Coming to the end, so how to have a catchy ending is that the ending usually ends with a prayer. In prayer, you cannot really include anything catchy, but what you can do beforehand is that you can make a very, very short and crisp summary of whatever arguments you made in that 15-minute time period, or that 7 or 8-minute time period. What does that? It basically gives you an edge over the rest of the participants, that whatever arguments you made, the judge should not forget कि अगर उन्होंने कुछ नहीं भी नोट डाउन किया हो आपके वर्बेटिम में, आप जो उसको समराइज करेंगे लास्ट में, the judge will remember that okay, this counsel made this particular argument and I need to take note of that. That gives you a very good edge over your the rest of the participants. So do that with consideration to how much time you have left. And even in case of time, they are they are usually quite lenient about the time, although not in every case. Now, if the fault lies with the organizers, usually they give you an extension. So no need to worry about that, or no need to panic. You can just ask for an extension to the judge, and if the judge grants it, your marks will not be deducted. So moving on to the last point, it would be practice. Now, I can't stress it more about how practice is important. So as soon as you submit your memo, whatever time that is left between your actual moot court and your memo submission has to go on to the practice. Make your researchers sit with you, make them hold a watch, and make them calculate the time that both of you as speakers are taking to finish your arguments. Also, make your researcher have a list of all the cases and all the precedents, all the resources that there are being used, so that in some moot cases, there is a concept called chit passing, where your researcher, where let's say the judge asks you a question, your researcher is allowed to pass you a small chit writing the answer of the same. So not every moot court allows it, but in some moot courts it is allowed. So it is very important for the researcher to be vigilant all the time. For the speakers, it is extremely important to practice as much as you can. And yes, make a script. Like I think Amisha was talking about making a script. So you can't go to a moot court, write with your memo and nothing else, and a couple of copies of judgments here and there. You have to make a script. You have to know what you are saying, what you are going to say about a certain point. You can't just hover around the topic like that and just keep saying, oh, I cannot recall that, oh my god, I cannot say this because I haven't written. You have to have a very perfect script that is prepared, and you have to present it in front of the judges. But also make sure that you're not too strict with the script. Let's say they are asking you to skip a particular part and you are not able to skip it because it's written in your script. You have to be very clear with that. So with that, I'll be ending my part. And my part was very basic about how to go on with the art of advocacy. But there are certain rules that you have to follow while giving your oral submissions, and I think my friend Shivani would be able to better take you through it. So I'll hand over the mic to her. Okay, Shivani, you may take it further.
I hope I'm clearly visible and audible to everyone.
Yes, you are
Yes,
visible
Shivani.
and audible.
Okay, thank you so much, and especially to Harshita for giving such a good introduction to all of us. And now I would like to take further the all-around workshop, and I really thank Pratna for such an informative session. And now I will be giving you a good introduction and information about what are the stages in the proceeding of a case. Proceedings in the courtroom basically differs on which kind of mood you are presenting. Like we have trial advocacy when it's a criminal matter, then we have civil proceedings, then mediation, which is very different, and arbitration and civil cases. All these, as the cases differ and as the matter differs, the stages of the proceedings as well differs. But right now we are limiting the workshop just for the CIM purposes. So I will be telling you all the stages that is necessary for in a normal civil case, and which you would all be we are expecting that will be following in the
Sorry
CIM
to
all
interrupt.
round.
There are queries related to that. You are not audible, but you are completely audible to me. So everyone is requested to check the internet. To check the net.
Thank you, Harshita. So I'll be starting. I have basically categorized all the stages in three broad heads. First is opening of the case. Second is the presenting the matter or the case, and third is closing the case. So first of all, there is a particular format and manner that you use while presenting yourself as a counsel in the courtroom. So you have to use all the words, all the manner, all the formalities of court craft to make a good impression on the judge, so that whatever you have prepared in your previous stages, like in the research and the memorial stage, does not get wasted, and you score very well. So first of all, the opening of the case basically begins when the court master is there. That person after greeting the judges and informing everyone about the proceedings of the case, that how much time would be given to each counsel or each speakers of the teams, and how much time would be secured for rebuttals and all of that. But when the court master says that now the petitioner or respondent can come and take the podium or dais. So dais is basically called to the podium, which is the place basically given to the counsels to come and present their case. So that is called dais in court proceedings. And when the court masters ask the counsel to take forward the stage, then the counsel basically stand up on their seat and take the permission of the court or the bench or the judges that whether they can proceed with the case. So you can clearly say the counsel seek permission to approach the dais. And when they nod or they say yes, then you proceed and take the dais. And you go on to the dais. First thing you do is to take permission of the judges to address the bench. So addressing is very important thing. In addressing, basically you seek the permission of the court or the judges that what term basically you would be using to refer them throughout the proceedings. So you can use any term. There are a lot of terms, like for example, your lordship, your ladyship, your honor, my lord, the judge, the bench, or sir, madam, and whatever you find. But there's a distinction that in High Court and Supreme Court we have, which is the higher judiciary, we can use any term which we like. But when we are in the lower judiciary, like the district courts, the metropolitan court, or any other session judge or court, then we cannot use your lordship, your ladyship, and my lord. So please avoid that thing. And I would personally suggest you to please avoid using your lordship or your ladyship or my lord, because many a time what happens is that the judge basically questions you on that very thing, that why are you addressing as your lord, because there's a BCI rule which says that you should refrain from using those terms as they indicate the colonial mindset of the country. So, but it is not strictly restricted, but I would suggest you please do not use that. It might seem very fascinating, but it might get you in trouble if you're not able to handle that in the court proceedings. So, and one thing in this stage as well, please decide beforehand that what term you would be using in the proceedings, and get your tongue very familiar with that thing, because you have to use that throughout your proceedings, and you need to be very familiar and have a very good command on that thing. So decide beforehand that what term you would be using, and seek the permission of the bench, whosoever is there. And please make sure you know that how many judges are there, so you can, when you are in the courtroom, so you can accommodate your sentence. For example, you can say that the council seeks permissions to address the bench as your lordship or as my lord, or maybe collectively referring to them as your lordship, because there may be many judges. So you can refer to them as the court, the bench, whatever you feel like is good for you, and you have a command on that thing. And once they say yes or no, because many times it happens they do not say yes, because it's a very the beginning of the proceeding and they are mostly looking into your memorials. So just look at the judge and have an interaction with them, so you know when they are nodding, so you can proceed with the proceedings. And when they nod or say yes, then just thank them that much obliged, your honor, on the bench. And then you take the third part of opening of your case, which is the stance and jurisdiction. And it is very, very important. If you make yourself wrong here, then there will be a very bad impression on the judge, and you might lose a lot of marks. And this will impact your entire proceedings in the case, because the judge might, point it out again and again. So, in the stance and jurisdiction, basically you state. Introduce yourself, that who you are, in which capacity you are, in which matter you are, and why are you in this particular court, like what is the jurisdiction of the court. So if I give you the example, so I'll be like, for example, we say that the name of the case is A versus B, and this is the counsel for the petitioner, and we say, for example, it's a Delhi High Court and a writ jurisdiction matter. So we can, you can simply say, for example, your lordship, this is the counsel for the petitioner in the matter of A versus B, uh, in the Honorable High Court of Delhi under its jurisdiction, which is mentioned in Article 2 to 6 of the Constitution of India. So you have to state it very precisely, very clearly, and make your voice, a bit strong while you're stating this thing, because you have to inform the court. And one more thing, that if you have prepared a transcript for your all arounds, because mostly we prepare that thing and we keep our memorials with us, but we prepare transcript, so that it is easy for us to interact with the judges, and we have headings on the pages. And if you are using a transcript, then make sure that you write the page number of your jurisdiction in your transcript, because the judges might ask you that, counsel, can you just tell us that on which page the jurisdiction of this court is mentioned in your memorial. You can state, so you can just make a reference to your transcript and just tell them. So just be very precise with that thing and keep a check on that. So, and once you inform the judge about the stance and jurisdiction, just thank them, and then your case or your basically the proceeding start, which is the second category or second part of the oral rounds, and that is very crucial. And please be very very precise and well prepared for that, because that's where it is decided that whether you how much marks you will be scoring exactly. So the second stage, uh, which is basically, first of all, in this, we basically there are two things in this. Is first is the taking the permission for stating the facts of the case, and then the arguments round. So in the first, once you are done with your jurisdiction, then you ask the court that the counsel seek permission to state the facts of the present matter.
Shivani, can you be a little bit slower?
Okay, but you
You
guys
want
do
to
not have to worry
understand the
about
things
that.
very
You can share
clearly.
the and you can find all of these things online on Google and YouTube, and I can share the transcript with you people as well, so you do not have to worry. Uh, so basically, this is very crucial stage, and I'll try to be a little slower. So once you ask for the permission, okay, so you have to ask for permission at every stage in the courtroom to make the judges that at which stage you are, because most if they because it sometimes happens that they do not listen to you. So you have to inform them every stage that where you are actually proceeding, so they are quite familiar with you and they listen to you. And here, when you come to the second part of your presentation, first thing is you ask permission to state the facts. And mostly it happens that they give you the permission that yes, counsel, you can proceed and you can state the facts of the case. And then when you state the facts, uh, please be very precise with your facts. Summarize your facts as much as you can, and make pointers in your fact sheet. Uh, Also, one more thing which we have really learned is just state all those facts which are necessary for your arguments, and do not go and telling each and every point, because you have to save your time and make sure that in stating the fact you have hardly have 2 minutes or 3 minutes, because most of the time it happens that the judges have already read the moot proposition, so they're familiar with the facts of the case, and they even just say that counsel, we are already familiar with the facts of the case, so you can proceed further with your arguments. But if not, and they ask you to state the facts, then please state the facts very precisely and in short. And one thing which I personally suggest you, that please state the truth when you are stating the facts. Do not mold the facts, because you have to mold the facts already in the argument round. So please just state the facts as they are given in the fact sheet, and be very well versed with the facts of your case through proceeding throughout your proceedings. And yeah, and one tip I would like to give for the if you are from the respondent and defendant side, and if the petitioner or prosecution or plaintiff has already given the facts of the case, then it was their side to present. Then, if you know that the judges are very interactive throughout the session and all of that, so sometimes what the respondent side do is that when they are asking for the permission of the facts, they say that if the bench is well versed with the facts of the case, then can you proceed to the arguments directly, as the petitioner has already stated the facts and we agree with them, because they want to secure and save their time for the argument. So it sometimes happens, but sometimes the judges allow, sometimes they do not. So if you want to use that trick, you can use that for securing and saving your time. But be very prepared for that, because they might get that thing might get you in trouble if the judges ask you why and you should state the facts. So just be very well prepared with the facts of your case, because you have to state them in the fact statement and also in the argument round, and you have to argue through with your facts throughout the proceedings. And once you state the facts, please conclude the fact statement that you are stating in your oral rounds with a line that now, if the bench is well versed with the facts of the case, then the counsel would like to proceed with the issues and arguments. And once you say that, and the court gives you the permission, then proceed for the issues and the arguments, which is the most prominent and most crucial part of your oral rounds. And then here is where the arguments begin. So when this round begins, first of all, you have to mention that how many issues are there in your matter, and in which order you will be dealing with them. And please state and
Shivani, sorry to interrupt you. I had to clarify something. I'm continuously getting this query of registration and everything. So this is very clear that we won't be opening the registration again. And but for you guys who could not register, we have this thing that you can participate in a moot court competition as a researcher. So what we can do is we can make a separate WhatsApp group where all those who are interested in participating as a researcher can be added. And whenever any team is in need of a researcher, we will ask them to approach the people added in that particular group. But you won't be an MCS member. You cannot register now. You cannot participate in CIM. Sorry for that, but everything is time bound, so you should have registered on time, and we cannot open the registrations again. You can participate as a researcher, as we have told earlier as well. So yes, Shivani, continue.
Thank you, Deepti. So let me repeat the argument statement. So first of all, that I'll be taking up the queries later on. That first you have to mention that how many issues are there in your matter and in which order you will be dealing with them. And while in the argument round, please state the issue first of all, and then begin with your argument. And once you close the first issue, or and the judges are satisfied with your arguments for that particular issue, then proceed for the next issue. And you can do that by just stating that. There are four issues in the present matter, and the council will be dealing with them one by one. And the first issue in the matter is, for example, whether the particular law is valid or not. And then you have to submit the stand for the party you are representing, and you will say the very first line of your memorial that the council, on behalf of the petitioner, submits that the particular law is valid, and for this the arguments are this. And then you start with the arguments of that particular issue which you have mentioned in your memorial. And in the argument rounds, please listen carefully. In the argument round, it might look like that you just have to go and read your memorial. No, you do not have to do that. It's very rhetoric, and it's like it is not suitable, and no one listens to you if you just go and read your memorial. No, please read your memorial, read your arguments which you have mentioned, written in your written submissions. Make a transcript, and if not, then please short down or highlight, or make sure that whatever you are going to state then is very precise, is very limited. And please make a timeline that how much time you will be devoting to one particular issue, so that all of your issues are represented by you, and the judges know that in which issue what you are claiming for. And in this argument round, basically it looks that we have to present a speech and all of that, but no, it is not at all like that. Once you start with your arguments, you are just stating the facts and reading and all of that. And the moment there would be a moment when the judge will question you and they will interrupt you. And you have to stop at that very moment when the judge starts speaking. Please stop there. Look at the judge. Listen very carefully to him or her, whatever they are saying. If they are making a remark, listen to and make a remark in response. And if they are asking a question, listen to that carefully. And if you know the answer, as Prarthana said, answer it. If you do not know the answer, take a pause for 10 seconds, think about it. If you can answer, answer it. And if you can relate it, relate it. But if you do not know anything about it, please keep yourself silent and please plead ignorance. And pleading ignorance is basically you can state there that the council does not have knowledge on that particular issue, so uh, would like to beg the apology of the court. So you can just ask them, and the judge would give you apology. And if they make a remark on that thing, please listen to it, accept it, and move on further. And while you are talking to the judge, please look at the judge only. Listen to him, talk to him. Make sure that when you are talking to the judge and having an interaction, it seems like that there's a conversation going on, or there's a discussion that is going on. Just whenever there will be a time when the judge will say something, then you will respond, and then the judge will again counter you. Then you have to counter argue. Let it be, let it go, and let's just keep the conversation going between you and the judge, and let it be. Does not matter how much time it is taking. And if it is taking very long and you feel that your case would not be represented, then just ask for time extension. For example, you can say that your lordship, the argument is very long, so I would like to plead for extension of 2 or 4 minutes for completing my case. And if the judges, find your case interesting, and if they think that just to answer the judge's query you are asking time extension, they will give you. They are mostly very lenient in giving time extension if you are having a conversation with the judge and you are satisfying their queries, their doubts. Because in the courtroom, the counsel basically that you would be representing is in a position where you're claiming something from the judge, and they have to decide whether you give whether they will give you that thing or not. And that would depend on in which like how much good capacity you present your case. So they will ask you many questions. So you have to answer each of those questions as with as much dignity, as much with respect and knowledge as you can. And this Q&A session as well, while you're talking to the judge or having that discussion during the arguments round mainly, you can think that what questions the judge can ask you and you can prepare. So basically what happens is that the judges ask you all those questions which your opposition can raise on your case. So uh, one thing for this is that please read your fact sheet very carefully, do your research, do your drafting on your own, prepare for the oral rounds with the memorials as much as you can, and try to have as many discussions and conversations on your arguments. If there is someone with whom you can have the discussion, have with them. If there is a team, have do that with them. If not, then just think about yourself that what would be the probable like situations and questions that the judges can say and the opposition can raise, because nothing is absolute. There is always going to be a reaction to every action and every counter argument to an argument. So think about that and then you can prepare yourself. So whenever the judge says something and question, you can answer that thing in a very good manner and very easily and quickly. So that makes and lasts an impression on the judge. And also, uh, uh, one more thing is that when the judges ask you a question, I would just prefer that you answer that question in 2 or 3 sentences. Make it very short, very crisp, but make it a bit descriptive so they understand that what was the question and what is the answer or the argument to that particular thing. And if something happens and you are not able to understand what was the question of the judge or what he was saying, then you can simply ask for repetition. And if not, then you can just mold the situation and rephrase the sentences in whatever way you like. So for this whole oral arguments, the one thing which is the key is be well prepared. Like the law, the facts, the arguments, the decisions. Do not rely that if the judge will say something, you will read from the memorial. No, try to learn and remember everything. And if not, and then it happens that you forget. And please, in your transcript, write all the laws and all the names of the judgments and the citations and all the sections and articles that you are using, because you have to state them very precisely. And if you're stating a judgment, for example, if, for example, you say that it was the Indira Gandhi judgment, and the judge might say that you are stating the Indira Gandhi judgment. They can point out and they say, can you just tell the full name of the judgment and the citation? Then you just look at your sheet and just make a reference. That's the only way which is expected, which is formal, and which should be used. It's not like you are opening your memorial and just finding it out. Please avoid that thing. And also, if you're making the transcript, make sure that wherever your issue or wherever you have a judgment or a decision or a statutory provision, make sure that you write the page number of your memorial where it is mentioned in your transcript, because sometimes the judges get lost themselves in the memorial. Then they just look at the council and ask that, council, where are you reading, or uh, on which page this particular law is mentioned. So you can just make a reference and tell them that it is on page number, and page numbers no one remembers. So you have to make a reference to your transcript and your sheet that you have on your podium. So just be prepared for that. So prepare everything in advance. Your transcript, your memorial, make use these highlighters and chips and all of these things in a memorial to make sure that whenever you want to know something from your memorial, you just open it, you find it out. That's it. And in the arguments round, please look at the judge and do not do the reading and rhetoric thing. It's highly disregarded. So be prepared, but you can use your transcript and your memorial for looking to the laws and all of that thing. And one more thing which happens usually in the moot court is that when judge asks a question and it is absolutely against your stand or your party's stand, and what the counsels do, they just object very objectionably. Please avoid that. Do not object to any question of the judge. If they say something, listen to them and be very consistent and very formal listen to them, and you can then say that whether you agree or not. But you have to use very precise, very formal, and very moderate language for that thing. Uh, also, and yes, as Prarthana said, that once you are done with all your issues, make sure that you summarize your entire case in 3 to 4 lines. When, like, for example, you're done with your, for example, there are 4 issues, and you say that now the final argument for the issue 4 is this. Then just make a statement that now, as the council has presented all the 4 issues, I would like to summarize the entire case in 3 or 4 sentences. State that thing, and that's the most important stage where the judge just look at you and listen to them, because they also want to remember that what was summarized in the whole proceedings, because they also forget so many things. And after this, you have the concluding of your case, which is the prayer and thanksgiving. So in this case, what basically happens when you're done with the your arguments, you just go and say that now, if the judges are well versed with the facts of the case and satisfied with the arguments of the counsel, the counsel seeks permission of the court to proceed for the prayer. And prayer is one of the most important stages in your proceedings. Even if you find that one of your issues was left out and you couldn't say because there was shortage of time, or due to any reason, make sure you always secure 1 minute for a prayer, because prayer hardly takes 1 minute or 2 minutes. But please always secure your time, and if you do not have the time, please seek time extension from the judges. And there's a very formal thing, usually the council seeks permission to for a 2 minutes time extension for stating the prayer, because prayer is the stage where you exactly tell the courts that what do you want in the proceedings. Because if you do not ask them what do you want, they won't give you. Although there is no decision or no judgment thing in the memorial, but you have to say the prayer. And prayer is the only thing in the entire proceedings where you have to read the entire memorial sheet of your prayer from the memorial itself. Look at your memorial and read the entire line, whichever you have written, whatever in whatever method, like wherefore in the light of the arguments presented, facts stated, and laws mentioned, the council demands for the petitioner or respondent 3 points. First is like first, second, third. You state them, and then you have this line that and any other order which the court likes that they should uh, pass in favor of the party in good faith and justice, they can pass it. That's it. State the prayer. And one thing which we are using nowadays is that while you're stating your prayer, you can use your right hand and put it on your heart and then state the prayer. And while you're stating the prayer, please take your left hand on your back, put your right hand on your heart, look at the judge, stand straight, and just state the prayer, looking once in the memo and then at the judge. That's it. State the prayer. Once you are done with your prayer, thanks the court in a very appropriate manner. Just do not say thank you. No, you have to say that in a very formal and appropriate manner. Just say that it was the honor of the council to plead before the honorable bench along with the co-counsels. That's it. Then you say that, wrap up your files and leave the podium and go back to your seat. And one thing which I would like to say, which we got left out, is that during the proceedings, two things which you have to make sure, and you cannot, like, something which you can prepare in advance. One is your hand movement, and second is your voice level. So as far as the hand thing is concerned, mostly people do is that they lean on the podium, or they're just using your hand to point at either to the judges or to their memorial or to the opposition. Please do not do that. Keep your hands on the podium or on your sheets, please. Do not, and please do not point out towards the judge or to the opposition. And if you have to make a reference to your opposition, please refer to them as them, like as the opposition has raised this particular issue, because you have to refer or make a reference or address your opposition in a very dignified manner, because there the judge gets to know that how much respect you have for your opposition. And as much respect you give to your opposition and as to the judge, the respect will be given back to you. So as much respect you want, please give to the judges. Please treat them with as much respect and dignity, because that is like very crucial in the proceedings. Like we are pleading in the courts of justice, so you have to be very formal. And as far as the voice thing is concerned, first and most important, do not ever raise your voice against the judge. Do not ever raise your voice against the judge. Keep your voice
Shivani,
moderate throughout.
I'm so sorry to interrupt you. I just need to clarify one quick thing to all the participants, that please do not call any of us for any queries, like any of the executive member. It's very difficult for us to pick up your calls and answer your queries. You can message us, you can DM us, you can write a mail to the MCS email ID, and we'll be responding as soon as you can. But it's very difficult for us to take calls for each one of you. So please just be a little cooperative with us as well. We'll be happy to guide you as much as we can, and we are actually here for that only. But it would be very grateful if you could just drop in DMs to us, or you can write on the Insta of the MCS, or you can mail us. We'll be responding to you. Don't worry, we do see the mails like in every 30 minutes, and we'll be responding to each and every single mail of yours. Thank you so much. I'm so sorry, Shivani. You can continue.
It's okay. And yeah, like as far as this voice thing is concerned, please have a very moderate voice throughout the proceedings. Whatever your normal voice is, just keep it, but be, make it a bit stronger, because you're arguing. You're not saying something or giving a speech. Make it a bit stronger, but use a very moderate proceeding throughout the court, so that the judges, the opposition, and if the people are sitting there, as audience, they can listen to you, and especially the court master. And yes, and if you have something to repeat it throughout your proceedings, repeat it and put a little bit of emphasis on it. It is if it is important and the judge should note it down. Then please raise a little bit of your voice, but do not raise it too much. And lastly, facial expression, which makes a very lasting impression on the judges. Please control your facial expressions. Do not laugh, do not smile. But yeah, if there's a situation, if you're having an interaction with the judge and there is something which is, if the judge is smiling, you can smile a little bit, but do not make any fascinating remarks. And especially if it's a part of your, if the opposition is presenting their case, then please make sure that you either just look at them, or you're just looking into your own sheets and just writing down something and whatever. Avoid having any interaction with the judges during the presentation of your opposition, and control your expression as much as you can. But yeah, but you change your expressions with the changing scenario and mode of your proceedings. So that is the thing. And I don't think so I've left out anything. But if you want anything to ask, you can text that in the chat box. And as far as this, as I said, this permission thing, this you have how you plead apology and how you seek time extension and how you greet the court. All of these things you can find them on Google very easily. It is easily available there on, and not go to YouTube and watch videos of moot court competitions, and you can see that how they are reacting to it. And I try that, and although we will be sharing the PPT that we are sharing on the screen in the drive folder that has been given to you, and if I try to make up these addresses and all of that as well in a sheet and try to add that as well if it is possible, but no assurance as of that right now. Thank you.
Shivani, there are questions in between as well there were. So let me share it with you. First is, what is transcript?
Okay, so transcript is basically something, is you can say a sheet of all the things which you want to say in the code. Like for example, if you watch a video, then you have the captions, and if you download all the captions in a sheet, that's called a transcript. So for the oral rounds as well, we try to avoid using our memories because it's very chaotic. So we use a transcript. Transcript, you can use a sheet and write out whatever you will be saying in the argument. So it's very easy and very convenient. And transcript is something which you have, which makes you be very formal and be very frequent, because reading from your memorial is very hectic, and you might forget many things. So it's better to prepare a transcript, and especially for how you will address the judge, what will be the term you're using, and your matter, statement, and prayer, and all of that thing. And one thing I advise you all, please prepare a day or two before your oral rounds, like for all these catchy terms for the like for your lordship, your lordship. Please make yourself familiar with that thing. How you will how will we pleading the ignorance? How will we seeking time extension and all of that thing? Because during the round, it's very difficult to remember all of these things.
Shivani, would you like to share our semi-final experience? Because there is a query that how should we address the judge?
Oh, you can address the judge in any way. So let me give you, for example, Harshita is my judge right now, and I am addressing her from the very beginning. So, for example, I'm on a seat, and the court master has asked me to start with my case. So I'll get up on my seat, and I just see that the counsel seeks permissions to proceed further for the case. Harshita, will you nod or say yes?
Sorry, there was some network issue. Sorry.
Okay, let me begin again, and please nod and say yes. Okay. Uh, the council seeks permission to proceed further,
Yes.
right? And you go to the podium and you see the council seeks permission of the bench to address it as your lordship throughout the proceedings.
Yes, you may.
Much obliged, your lordship. Um, the council in the present matter, the council is representing the petition in the present matter of A versus B in the High Court of Delhi under its writ jurisdiction mentioned in Article 2 to 6 of the Constitution of India. And now, if the court permits, if it pleases the court, then the council would like to proceed further and present the facts of the case. That's it. That's how you address and start with that. But you can change it as you like. Just try to be formal and use all of these terms because the judges who will come to judge you are also familiar with the proceedings and all of that.
Can we highlight points on the memorial submitted to the judge?
No, you cannot do that. But yes, in while look, whatever memorial you will be submitting online and whatever copy you will be bringing on the day of your oral rounds will be one copy. Like it should be same. There should be no changes in the soft and the hard copy. And as to make highlight, you can do one thing is to whatever is something which is very important for your case, especially in the arguments, make it either make it bold or underline it. And if you want to state something very precisely in the court, then while you're giving your arguments, you can just clearly say that now the council would like to, like for example, आपको कोई law, for example, you have to mention a law, and you can just say that the council would like to mention this particular law, which is very crucial for the proceedings, and this is mentioned on page number 14 of the memorandum in paragraph 2. So that's the way.
How to object politely? Please give an example. I think we have shared this. We have
Okay, so
shown
one thing
this.
is that you, like in normal proceedings, you do not object to the judge. Objection is something which happens in trial advocacy. So you do not object to the judge. But yes, when you are having a conversation or arguments with the judges, it is always that once the judge will speak you, then you will speak. So because both of you have to give time to the other person so that you also get the time in return. So when they are saying something, you can respond that the council do not be very objectional, means do not very directly say that I do not agree with you. Say that no, your lordship. The point is not which the council is trying to make here. Rather, the point is this and that. And if you think that whatever you are saying, the judge is not understanding, and you have to repeat that thing, try one thing that rephrase your sentence and try to do it any other way, so that it does not look like that you are repeating all of that stuff.
Can we say only honor, your honor, if we don't want to use my lord?
Yes, you can use your honor, and your honor is something which is used in the lower as well in the superior judiciary. So your honor is you can use it in any court.
Can we use your honor for multiple judges?
Yes, yes, that's what I want to say. That when you seek the permission, okay, so just first of all, you can see easily in the courtroom that how many judges are there. If it is just one judge, you can say anything. But if there are like two or three judges, although if there's a the case is in the lower judiciary, for example, the session, the metropolitan, or the magistrate, there are no benches. Do not use the term the bench. Please avoid that thing. And it would be only happen if it's the high court or the supreme court. And when you are taking the permission of the court to address them as your lordship, then it means that you will be referring to them collectively. And if later on someone says that you just ask for permission for your lordship, or if there's a lady judge, and if you ask for your ladyship, or like whatever you say, then it usually it does not happen. And if it happens, then you can just argue, and then you just can say that the general clause that say that he means she. So that is the whole situation. You can just give a look to that, but it does not happens. And yes, as this person has said that you can use sir and madam. Please, personally, we would suggest you use sir and madam. That's very convenient, and even the courts, request the councils to use sir and madam.
Uh, yes, I think there are no more queries in this platform. Ekagrata, is there any query present at YouTube platform?
Yes, there are many, and also Karan and Astha can also answer these queries because some were
Yes,
sent
as
later.
per the rounds, whatever the query is about.
Okay, and Nitin has asked that how much should I rely on case laws for memorial?
Oh, okay, I'll take that up. So for case laws, yeah, they are important and you can rely on that. So for example, there is a case law which is similar to the moot proposition which you are preparing your arguments for. Then yeah, you can rely on that. But just you have to see if there are any minor changes in the facts of the case. So that completely changes the situation of law, application of law at times. So just ensure, but yeah, case laws are important and you can rely on case laws uh, for your memorial.
Just to
Okay.
add on to Karan's point, sorry, Kagrata.
Yeah.
Just to add on to Karan's point only, please do not make your memorial heavily on precedents. That's a wrong thing to set up because when you're going into the court, yes, definitely in Indian courts, the precedents does help you a lot. But first, get your points and arguments in your pleading straight on the basis of your law points, your legal provisions. Once you have actually established that from the law through the legal provision through the sections, then you can use the case laws that yes, similar judgments have been given in previous cases, but do not just straight away go for precedents, so do not heavily rely on them. Like
Also,
don't
uh,
like just only last thing, just do not fill your memorial with a lot of cases, and actually when you go into the moot court, then you don't even know why did I stated this case in my memorial. We just cite them, but we do not even know the facts. If you're citing a case, please just read through that case, not if fully, of course it's not practically possible, but at least you should know the crux of the case, the facts of the case. The judge can ask you, so just be cautious about that.
the more thing you should be focusing on is to not have more number of cases. Focus on, even if you have, let's say, just two cases per issue, your focus should be that you have to frame your arguments, that you have to derive your arguments from that particular case, that how this case is relevant to you and how that case helps you here defending your client.
Ali, this is a workshop for LC2 students. So, yes, we all are from LC2.
Another question, Karan, is that can you briefly differentiate between summary of arguments and argument advanced?
Sure. So summary of arguments is basically the as it says, summary of arguments. Arguments advanced is your arguments in detail. So for example, arguments advanced for a particular issue can go from 4 to 5 pages, but the summary of arguments has to be confined to just 4 to 5 lines or a paragraph at max, because you have to adhere to the page limits, right? So for summary of arguments, the page limit is 2 pages. Let's say you have 4 issues in your moot proposition, so half page per issue, that is one paragraph, max 6 to 7 lines per issue. So you have to, the summary is very crisp. You have to you just have to state that okay, based on this provision, this is the this issue, this provision is applicable in this issue, and hence this is what you are trying to argue here. That is it.
Basically, summary is something which helps the judge to know that your arguments will be based on these facts. These, like, what are the legs of your argument? What are the pointers? Summary is just the pointers of your arguments. That's all. Like, the judge will know ki, okay, you will be arguing on these points, so he'll not interrupt you in between if you state the summary beforehand. If you tell the judge that I'm going to argue like in this manner, so that the judge will basically know, okay, these are the pointers that will already be covered by you. So he'll not basically interrupt you in between. Okay, you'll be covering up in your further argument. So it gives a map, it gives a layout to the judge. Okay, these are the structure of your argument. That's what summary is.
So I think the Drishti is asking question regarding the timeline. So yeah, we'll inform you before 25th. The oral rounds are not on 24th, they are on 25th. And before 25th, you will be informed that this particular memorials have been selected for oral rounds. So don't worry about that. You will be informed well in advance.
We'll be declaring the memorial result on 23rd, and on 24th we'll be having a online meet in which we'll be basically doing the matchups. So we'll be giving you the team code. So let's, as I mentioned earlier as well, if your team code is 01, so you will know that who you are against. You will not know the name of the participant. Of course, that is something that we'll maintain. Like, we'll not disclose that, but you will know the number, the team code number, that this is the participant who will be you will be opposing with, and this would be done in front of you. So as you know that we have already allotted the sites, so like, first years will have a separate meeting and second years will have a separate meeting, of course. So we'll put two bowls. Like, this is something which is actually done in a moot court competition as well. So in one bowl we'll have all the chits from the petitioner side, and the other we'll have the chits from the respondent side, and we'll randomly pick out the team codes, and the matches will be done in that particular case. Similarly, if there's any apprehensions in allotment of side, the allotments of side are also done on a shuffle and a random basis. We have not seen, as soon as we have got the registrations, we shuffle the names and we allotted them randomly. So just to be very fair in our procedure for the CIM, everything is done on a very random base. We do not know any one of you.
Amisha, can you also touch upon what is the meaning of identification of legal principles?
I would like to interrupt and inform that all the updates are also being shared on the website, social media sites of Law Center 2 Moot Court Society, that is on LinkedIn and Instagram. You can also look it up and follow our pages too. Thank you.
Yeah, okay. Like, Agrita, what was the question?
Identification of legal principles. Could you please elaborate a little bit?
This is something that I didn't speak about, and I'm just a little bit clueless on what exactly does the person want from identification of legal principles.
So I think what the person wants to ask is that, okay, so for example, there's a legal issue you are trying to address, and so what legal principles are applicable here? Let's say
Proper analysis.
Yeah.
Ashita, you were saying something.
No, I was just nothing. Karan, you may continue.
Okay.
I was talking.
No, the
principles you can apply. That's what the person.
He is asking about the proper analysis, that what law to apply, and there is also one query that as we are from first semester, then how we will refer to other acts that we haven't read. So you have to research for that. That's why we have shared with you how to use SSC and Manupatra. Also, the moot proposition for CIM is from the Constitution. So that, I think you all are well versed with the basics of the Constitution, and as you have read that at the time of your entrance, so you will not get that much of difficulty in CIM.
Just to add on to Harshada's point, whenever you go for a moot, it is not necessary that we as mooters, we as budding lawyers would know each and every single act. Even in today's world, lawyers also are not aware about all the acts. There are multiple acts. You have to read, you have to pick up the bare acts and you have to read them. And to the identification of legal provision question, I'm so sorry, I didn't understand that question, but now after the clarification, so basically once you're reading the moot problem gives you a lot of hints. So basically, you have to pull out the provisions, you have to pull out the matter from the provision itself. As I mentioned, it can be anything like, let's say, right to privacy. So you know what is right to privacy and where you have to pull that out. So that is a legal provision. You have to identify yourself as you read. Every single word has a meaning in the mood, a mood problem. Once you pick up those words, and sometimes even straight away sections and articles are also given in the mood problem. Pick those out, read them, read the concept, understand the concept. That is how you identify. Because if a mood problem is basically it is made in a manner which will actually tell you, okay, this is related to this particular subject, and from there I have to basically pull out. Let's say if it's an arbitration matter, so if you read the problem, you'll understand that this arbitration matter is actually the first issue is only about jurisdiction. So go pick up the arbitration rules and then read the jurisdiction. From there you will be able to identify the legal provisions, something that you learn with time, you learn with the process of it. And there's a question about will first years be responding? No, first years will not be responding to second years. First years will only be competing with first years, and second years will be opposing the second years. So we will not. Of course, we also understand that there will be a fair procedure for the same. First years will be up against only first years.
Guys, also we need to wind up by 1 p.m. So what I'll do is I'll quickly share the rule book on my screen, and we'll just go through the rules one by one. So if you have any queries regarding the CIM and rules, just ask. We have to wind up by 1 p.m.
There is a query how to improve the English language. You don't have to use very high English. You have to use just very normal English, and in a very simple language, you have to do it all.
Just stick to the basics, because even if you use very heavy words, you will basically the judge will question you on that how did you use this word.
There are also questions that if only English can be used. So I think for
Yes.
CIM only English is used.
For all the moods you can only use English. There are certain specific moods in Hindi language, so for that you have to register separately. But normally all the moods that happens at a level like NLUs or the national moods that are done by our college or by any other colleges, it's normally in English. There's a mood that is done in Hindi by Amity, so if you really want to go for a Hindi mood, you can definitely register in that. But the standard language that is used is English in the courts as well.
So now let's move on to the rule book. So clarifications will be released on the 15th of March. By tomorrow, you'll receive your sites. The sites have been allotted. You'll receive your participant codes by tomorrow. You have to ensure that you maintain anonymity. Your roll number, your form number, your name, nothing should be present on the memorial. Otherwise, it will be disqualified. The draw of lots will take place on 24th. The results of the memorial round will be declared on 23rd. The deadline for submission of memorial is 21st of March. So, and the timeline is already shared with you. So please adhere to that. The memorial section we have already discussed in the first part of the workshop. So I'm just skipping that. So if you have any questions regarding the rules of CIM, please ask right now so that we can clarify it.
Alicia is asking why only English, ma'am. So you are typing this in English, so that shows that everyone is interested in
also,
English.
like when you took admission to the Faculty of Law, it was made pretty clear that the medium of instruction will be English. So I mean, the studies are happening in English. So anyways, you have to follow that.
The standard language that is followed in courts is usually English, like in today's generation. So that is what the moot courts are actually prepping us for. So that is why we use English as a language, because if you go in the high courts of other cities, there is basically then the language of that particular state is used, like in Maharashtra. So that is why English is a standard language which is used in all the courts. And that is why the moot courts also follow a standard language. Even if you go for a moot in Bombay or like let's say South Side, you will be seeing people using English. So it is not a problem for anyone to understand the language. English is something which everyone can understand.
Now, quickly moving to the oral submissions, you will get 10 minutes to present your arguments, to present your case. And in case you, as the Shivani mentioned in the oral arguments section, that in case you need more time, just ask for an extension. And usually judges are quite liberal about it and they give the extension. So about the marking of overall marking regarding this.
And just a
Yeah.
second, there's one interesting question.
Uh,
Like, if we do mistakes in moot, will you kick us out? No, we'll not kick you out. Don't worry about that. Everyone makes mistakes. Yes, there are just two, three prerequisites to be in the moot court society. Like, let's say if there's any event that moot court society is doing, so we as like you as members, we would definitely be expecting you to volunteer without even us asking you. And there is a prerequisite that you should be an active member actually. So just don't come into the moot court society and do not even, and you're not even participating in any moots is something that doesn't go well with the society. So yes, at least one moot is something that you have to do like in a year, and that is something that I'm saying one moot in a year is just like too much. So these are two three prerequisites that you have to follow if you're in the society. So we'll not kick you out, we always give you warnings for each and every single thing, don't worry about it.
Also, to help you out, so we are not expecting very great legal arguments from your side. What we are trying to test here in CM is that how well can you apply the legal provisions, and how well you can argue. You can argue for your side. So we are just testing your confidence and your legal application skills here. You won't be judged very strictly as far as the CIM is concerned, so that you can be a part of MCS, then participate in moot courts, and then improve your skills on various parts. And about the question that Namrata asked, that 45 marks is the cutoff. Yes, 45 marks is the cutoff. So there will be total 100 marks, memorial plus oral submission, and anyone who scores above 45, they'll be inducted into the MCS. And about the negative marks, there was this one question about negative marking. So, and for the mistakes. So yeah, I'll take these two questions together. So don't make silly mistakes. So for example, the penalties are mentioned here in rule 7.20. So here, see, the basic you can do is adhere to this limits, right? If you will adhere to these limits, there won't be any negative marking. And if you do not follow this, there will be negative marking, which is like a loss for you. I mean, you can easily score here. You can easily save your marks here at least. I mean, if the formatting is good, if the application of law is correct and it's decent, then you can easily score good marks as far as the memorial is concerned. That's it, I think. And this is the dress code that is in formals and blazer. So that is it. If you have any questions regarding the rule book or CIM or anything, just ask. We'll wind up in 5 to 7
How
minutes.
do you feel as a law student asking my seniors? How fortunate do you think you are being a part of legal fraternity? We are very grateful.
Yeah.
Okay, so I think there are no more queries. Ekagrata, is there any more query?
No, not here.
Okay,
All the
so
questions
let's conclude the session. Thank you everyone for joining us today, and with in such a huge number. And I hope now everyone is clear with the CIM process and drafting part. And there is one query related to dress code.
Dress
It is
code.
provided in the CIM.
Yeah, dress code.
And
Yeah, you have to be in formals. For males, it is white shirt, black tie, and black blazer. And for girls, it's the same. And I think the for CM, I think the traditional is also allowed for girls, right? Let's just.
Yes, the girls can also wear white salwar kameez and a black coat.
Black coat is compulsory.
Yes.
Yes.
so let's conclude the session, and we wish you all the very best for the CIM, and we are expecting all of you to come in the CIM. So best of luck. Let's.
Last thing, if you have any queries, just mail to us or text to any
Yes.
of us. We'll try to respond as quick as we can.
Yes. Please do
Yes.
not call.
Yes.
Thank you guys and all the best to each one of you. Looking forward. Happy mooting.
Thank you so much for being here and listening to.
All the best,
Thank you
guys.
so much, everyone.